We love that umbrella guy. All right. Thank you.
An army of one. Peace up, walk by, verbal clips, and they done. Yeah, stronger than the tide. I'm the wave maker. When it comes to false accusers, I'm the claim breaker. They wanna rack me up. When it comes to false accusers, I'm the claim breaker. They wanna wreck me, but I'm not backing down. Rolling through their hoods, bumping my own sound. Monetize the haters, raining ice and platinum grills. Pure determination, dropping these mic skills. That umbrella guy, fan in the whip, crushing keyboard jockeys with all my verbal clips. You wanna break me, but still I'm standing tall. And on you want conquering them all. Conquering them all. Conquering them all. Dropping the bass, I'll make them regret the mainstream lies and all of the threats. From a media, less truth and more disease. They can't run the dog, so they cling on like fleas. That umbrella guy, no, we're not playing. They ruin lives that should be paid. They really thought they could treat us like cattle. Ownership papers and roundups like chattel. That umbrella guy, an army of one. Step up, walk by, tell them they're done. It's not enough to laugh when we select them. We gotta stand strong and wreck them. That umbrella guy, an army of one. Step up, walk by, tell them they're done. Enough to laugh when we select them. We gotta stand strong and wreck them. So you want us to separate your heart from the artist? Now that umbrella guy bumps the hardest. And then we learn to forgive and forget. Nope, that umbrella guy ain't your pet. They wanna grind us down and keep us beneath. But this platinum grill has some iced out teeth. With verbal clips that'll do more than bite you. That umbrella guy crushing it just to spite you. We got a mind and now we're standing strong. Growing by millions as we all sing along. And ignoring the media slander that they blast up. Because that umbrella guy serves no master. For sure they'll take aim at our lives, but we're like lions being swarmed on by flies. Spirits locked out like water. It's that umbrella guy holding the water. We love our platinum grill. All these platinum grills.
All right. What's up, folks? Hey there. And how you doing today, Megan? It's been getting crazy all of a sudden.
Oh my God, the last 30 minutes of my life has been a shit show. It is insane what is happening right now. I like your new song though. Can we just
Yeah,
say
like
that's a
I was telling you, I've gotten bass obsessed. If anybody is curious about how much bass is in there, go out to your car if you got a good system, or in your house, turn it all on, and really listen to that thing. That thing will rattle your teeth.
It's fantastic.
Yeah,
I am so impressed by AI. I really am.
I love it.
Did you see what Legal Vices did? Did you see?
Yeah, I did. Here's fun. I'm sure he wouldn't care. He was like, "Hey, check this out. Do you think it's a little mean?" And I was like, "Mean? Have you heard what I write?" Like, it's great, dude.
Oh man, yeah. So there's some serious garbage going on.
Crazy
Oh,
stuff.
so the breaking news is that a new motion has been filed in the Laura Owens. I always say that. Laura
Echard.
Owens v. Clayton Echard. She wishes.
Yeah.
She has a new attorney. And this attorney is like, I feel like he should be somebody like Voldemort, he who shall not be named. It's like, I don't want to say his name because I feel like he wants me to. I think he really wants us all to say his name and say it loud. And he wrote this particular motion. Like, she finally found someone as unhinged as she is to, go scorched earth for her. So good for her, I guess, because that's what attorneys are supposed to do. This new motion that this guy has written is so offensive. I walked away from it feeling physically ill.
Yeah, I was like, I felt dirty reading. I was like, oh my God.
Oh yeah,
I mean, they're literally trying to
physically ill.
yeah, they're trying to destroy. I mean, the stuff, I was like, are they really gonna claim? Like, May and I were talking about it, and I kept thinking, are they really gonna claim I'm gonna say ARP? Are they really gonna
ARP.
say that?
ARP.
Yeah. Yeah,
Yeah,
ARP.
so now, as if he hasn't been through enough, they're now claiming ARP. ARP. ARP
Yep.
is great. That's funny.
Yep.
Yeah, that I guess during her deposition, she made a ridiculous claim about Clayton ARPing her. And that's really what he's going with. I mean, like, he is going with it, and he's basically saying, "And you weren't there and I wasn't there, so you can't prove it."
That's so
A
ridiculous. That that angers me more than anything. I mean, so in comic books, we just had a big name comic book pro. I'm gonna say off themselves. And it was because of accusations.
Yeah,
He had
horrible.
they were 4-year-old accusations. So 4 years old. You have accusations that he's talking to somebody that's 17. Now he was saying, I was not just talking to them, talking to other people. I had communication with them, and there were clips, he said, taken out of context. Like, she said something about I'm some kind of criminal thing, like I'm robbing banks or something. He was like, oh, you dirty
Naughty
girl.
girl. He
Yeah, I
said
mean,
naughty.
naughty
Naughty
girl.
girl,
That's it,
which is
naughty
not
girl.
that big of a deal, and not to mention, isn't he he's in Philadelphia, I think, or Pittsburgh. Where was he?
I don't remember.
Anyway, whatever state he's in, the age of consent there is 16. So, and even if he was hitting on this 17-year-old, it's not the worst thing in the world, okay? It's
I didn't
not.
see
I
it though.
don't think it is.
I
I don't
if
think that's what he was doing. He says he wasn't, but who cares? The guy literally offed himself because a bunch of people started a whisper campaign and canceled him and tried to make it sound like he was some kind of child, you know what,
yeah,
ARPist,
yeah.
which is not the case. And if you're 17, by the way, if you're 17, if you're out there right now, you listen to me. I am a mother of an 18-year-old. If you're 17 and you're out there texting adults, shame on you. Stop it. You know what you're doing. You're a 17-year-old. Stop it.
I
Like,
just
take some
what we
damn
saw
responsibility for yourself too.
come out. It didn't matter what was there. It was the allegation. The allegation undid him, and he had been working on. Like I said, his career had been on a huge upswing. He had created a very successful YouTube setup. He had this big art exhibition that was going on. Again, his career, it was right there where he needed to be, and 4-year-old pieces of communication, they were dropped in it, and it ended him. He put out the downside was it came out on April Fools. So everybody was like, is this
They
real?
didn't think it was real.
Yeah,
Yeah.
but I found out it actually there was a note written. It was 5 pages, as far as Facebook communications, 5 pages that named people. He was saying, these people ended my life. And he's going through asking friends can you give this to my mom? Can you do this or that? It was very worrying, and then he disappeared. So they brought in a private eye to find out what happened, or a detective. I said private eye. They brought in a detective to find out what happened, and apparently he ended his life. So
I read the entire letter, and
it's
it's
horrible.
heartbreaking. It's horrible. This was clearly a guy who had made the decision that he was going to end it, and it's very, very sad. And no one should be forced to this because of this. It is gang stalking. Thank you, chat. It's gang stalking, and gang stalking has consequences. It's not just mob action. I actually like the term gang stalking a lot better. Like, I do. Than a
Does it?
cancel mob.
Does it have consequences? I mean,
Well,
for real?
the ending of a life is a consequence.
Okay, well, this has happened before.
Are the people who are doing it going to get a consequence? No. No, but we
Okay.
should talk about them and we should say their names.
Oh yeah, for
This is
sure.
this is unbelievable. I mean, here's the thing though. I guess I don't know. I feel like if you could find that, and I didn't pay attention to any of this when it was happening. I mean, if they're out there canceling this person over these nebulous things, like what were the text messages even were they even like full text messages or
No, there
just
were just
his
pieces.
words?
It was
They're just
it was
pieces.
it was just
Hey, that
pieces
sounds
of
familiar.
communications.
That
Yeah.
sounds like
Well,
what Laura Owens gave to the sounds like what Laura Owens gave to the Sun. Just pieces of text messages instead of her full responses about her crazy ass dating contracts. No, it's just Clayton saying, "I hate you, I'll hate you forever." And she leaves out the part where she's like, "If you date me for a week, I'll have an abortion."
right. Well, you know, this has happened before. So back in 2019, there were allegations. Here's one of the articles covering it from Zoe Quinn. Zoe Quinn, you know, all the Gamergate stuff. Well,
Oh, I
later
know
on in it,
her. Mhm.
yeah. So she came out and she accused this guy of horrific things. We'll just say, like keeping her prisoner and all of this just madness. And he ended up just in a few days he was like, my life's over, and he ended his. And then you find out that all the stuff that she was saying, a lot of these, I don't know if they're a lot of them. She apparently has deleted a lot of stuff, so I have to go back through an archives. But there's articles that pick this up. I'm sure some of them archived the communications there too. But she was saying, for example, she wasn't allowed to leave the house during this time frame. You know, he was keeping her prisoner, and yet she was on Twitter texting about, hey, I'm going to be part of this play. And, you know, and again, there were just nothing fit. It was a clout grab and it cost someone their life and nothing happened. Like that bothers me. Like when you get to that point, you think finally, number one, there will be consequences, but number two, people will wake the fuck up and realize that this stuff is real.
Well, I just think they should stop doing it. Like, as far as consequences go, like at sometimes I think, okay, look at the Jennifer Crumbly case, for instance, which was really, to me, a very slippery slope. Like the Jennifer Crumbly case, you're holding a mother responsible for her son who did this horrible thing. And the evidence in the case, in my opinion, wasn't very good for the state. And yet they got it because it's an emotional thing and like
Right.
people want someone to pay for it. But I thought, oh, this is a slippery slope. You know, you start holding people accountable for what somebody else does, and it can go real bad. Like for instance, let's play devil's advocate here. We know that Laura Owens has she's threatened to take her own life several times. And in fact, sent an email to Dave Neal that said, the blood will be on your hands.
Sure.
So what happens if, you know, she does some, you know, mentally disturbed person does something like this and
Well,
names a bunch of people in a letter that didn't have anything to do with it because it was not, it's just a news story, right? So there is a slippery slope here where it's like, I don't know. I don't
it's
know
I
how
don't
responsible they can be. Although I think cancel mobs, and I think it's wrong. I think you should not try to cancel people based on this nonsense of, you know, someone says this. Well,
these also weren't like random journalists picking up a story. We're talking about people in your own profession that are taking
yeah.
aim at you. And they've done this for years. Like these people, I've dealt with them personally. The people that he named, I've dealt with them personally. The comic industry, it cannot be redeemed. It needs to be cleansed with fire and then rebuilt from the ashes. That's the only way that it will come in. So, I mean, I see what you're saying there. The problem is if somebody's putting out false statements and you know, like in the Zoe Quinn situation, they were false. I feel justified in saying that. What she did is turn around and play the victim. All these people, they're pointing at me. I've got to leave social media. Poor me. And people were like, oh, poor her. She's the victim. I'm like, you just took someone's life, you know? I think there has to be some kind of consequence to not reporting on something, but when you get down to when you get down to the person that's doing this, people that are making false allegations for clout, that's crazy. Like, again, the Laura Owens is very good. This new motion, which we'll look at because it's so crazy.
Oh, it's so crazy. Her attorney, I'm gonna call him Laura's attorney or Laura's lawyer. I just feel like I don't want to say his name. I swear. It's like I can tell that this guy wants to be famous. He posted his new motion on his website. He didn't redact anything. So he ended up outing one of her victims that I knew about and that a bunch of other people kind of knew about, but we were asked not to say anything. And so we didn't. Like, I respected that.
Yep.
Even though I got threatened by this guy's lawyer, but I guess we can say it now. His name is
Yeah.
Matt Mulvey. He was the former quarterback at Notre Dame, and Matt Mulvey was allegedly one of her victims in a fake pregnancy scam. And Matt Mulvey really needs to come out and tell his story now, because Clayton Echard is being accused of the worst thing a man can be accused of, next to child SA.
Yep.
And he's going to is Matt Mulvey going to just sit back in his bazillion dollar mansion in California overlooking the ocean and just watch another guy get his life ruined because he doesn't have the kind of money that Matt had to get him out of it, and the kind of lawyers? Matt Mulvey, you may have never heard of him, but people who follow football know who he is. The guy was a star quarterback at Notre Dame. He is a big time financial guy now. He has tons of money, and he is business partners with Joe Montana. You know that name.
Yeah.
And he's best friends with Joe Montana's son. And Joe Montana's son apparently had a run-in with Laura Owens too. I don't know what that run-in was, but I do know there was a confrontation there of some kind. And they've been hiding this shit for a long time. Now, I understand that they don't want to talk. I understand Matt doesn't want to talk about it, or, he's getting married or whatever the deal is, like he's embarrassed or whatever. I get it. But you've got Clayton Echard right now on the ropes, and this new attorney of hers is literally setting fire to the house to save his client. He's going to burn the entire thing down by making unbelievable claims now and trying to destroy Clayton's reputation in the community and everywhere else. Is Matt Mulvey just going to sit and watch it happen? I hope not. I hope he grows some balls, because up until now, Matt Mulvey has said he wants nothing to do with this. And his attorney has been sent out like a rabid dog to intimidate and scare members of the media who want to talk about this. I got an email from her that was absolutely wicked. Trying to scare me off of doing my job. Now, she didn't scare me, but I respected him because he is a victim. And so I didn't want to go forward. I didn't want to go forward to say, hey, I know who this victim is, because that's douchey, right?
Yep.
It's douchey. But now that Laura Owens' new attorney has outed him, it's out there. And it wasn't me who did it. And I would like to, for the record, say it wasn't me.
No, I mean, he
this guy
callously put out everything there. I mean, why I was like, what the hell is this guy doing, man? And you can tell,
burning it all down.
Yeah. It's take enough people with you, and maybe redirect the conversation. There was a big trial out of the UK, biggest trial like most people never heard of. There was a lawyer working with another lawyer, and they had a tryst, let's say. Guy was married. She claimed she didn't know about that. So she responded with anger. After the anger, though, she decided to fake harassment through computers. She decided she would send herself all these horrible emails and stuff. The only problem was she used a work computer. So she gets him arrested, though, because of all this stuff. And while he's in jail, they find out she's actually the one that's been sending herself all this stuff. So they bring her in, they let him go. And when they bring her in and talking to her, she accuses him of ARP. She's like, actually, this is what happened. What do? They rearrest him. So they start to investigate it. They find out, hey, wait a minute. she's lying yet again. So they let him go, and she realizes she's in trouble. So she gets with an ex and another guy, and they fake a kidnapping. They actually fake that this guy that they've accused, gotten arrested twice now. They pretend he kidnapped her and that he stabbed her in the leg, and she had gotten away. She calls up EMTs to come in and save her because she's bleeding,
Oh
and
my
they
God.
find out that was fake too. So
I feel
anyway,
like I've heard about that. I feel like I've heard this story.
so she gets well, you may have heard it because of the end result. The judge gave her discretionary life, which is a lot of nothing. That's basically, you can give her a year, and you can leave her up
Really?
to
I've never heard of discretionary life.
yeah. I'd never heard of it either. I'd never heard of the sentence. Well, it comes back, and that she appeals, and they find that too harsh of a sentence. For what I just told you, that's too harsh of a sentence. So they give her a much more lenient sentence where she's going to end up serving a few years, and that's it.
It's like the Ruby Frankie case. Like I can't even get over the ridiculous sentence in that case. And don't get me started on the state of Utah and how they don't care about abused children at all. In fact, in the state of Utah, if you want to abuse a kid, you have one shot at it because you'll always get probation on your first offense. So it's sick. It's really sick. So if you don't kill the kid or ARP them, you can do whatever you want to them.
Yep.
And you'll get probation in Utah.
Actually, that's pretty much every state, just to be honest. That's pretty
Oh
much
God,
every
that's
state.
sick, Tug. That's sick.
Yep. Well,
I
people don't
can't-
understand most violence done against another person, especially if they're, if they're outside your home, that's a real crime, right? But if it's inside your home, that's a misdemeanor, unless you do you hit them with a pow or something, but otherwise, that's a misdemeanor. Slap on the wrist.
Yeah, I learned over the last 20 years of doing reporting on child abuse that if you want to abuse a child in the SA way, just abuse your own, not somebody else's.
Isn't that insane?
If you abuse your own kids, no one will believe the child. The courts don't give a shit about the child. And in fact, that leads me to what the Hales.
Yes.
And we're actually going to start out with that tonight. I know we have a lot to talk about because we do. We have, there's so much, and it always happens 30 minutes before we go on the air. So I'm like, Tug, what are we going to do?
Yeah.
But actually, I'm glad that we got into this conversation because I'm really heated about this child abuse thing right now.
Hey,
And
let me note this too. If you like this content and you enjoy the channel, perhaps think about backing the live stream, because I just get the feeling that the material today will definitely demonetize this stream.
The audio, the video that we have from the Levy County Circuit Court, or the 8th Circuit Court, is going to be using some words that we can't use on YouTube.
Yep.
I have new footage of Judge DeThomas's because we wanted to see how he behaves in other cases. And I have this footage of this case that was about a protective order. A woman came to Judge DeThomas's to ask him for a protective order against her ex-husband. And one of the things that she's alleging in her request is SA of her child. And Judge DeThomas's, as you'll see, is not interested in that at all. He doesn't want to hear the facts of it. He doesn't care. He does. Dave Neal Raid. Hey, Dave, thanks for sending over your peeps. I didn't know you were live. Fantastic. Good to see you. And thanks for being here. I love Dave Neal. And
he's funny.
So for Dave Neal's crowd, we are going to get to the Laura Owens, the new motion. We're going to do something else first. We're going to talk about a case in Florida.
Yeah, I would have added that in, but it just hit right.
It just happened.
I set them up. I set up the live streams I tried to optimally 2 hours before. That way, they said YouTube notices them. If you set it up at the last minute, I mean, people don't know it's there, but YouTube also won't share it half the time. So, when something hits within those 2 hours, though, unfortunately, if I were sitting right here, I could change it up. But if I'm
Yeah,
not,
it's okay. I mean, look, breaking news happens,
yeah,
and we're going to be here for a little bit. I'm on spring break, so I've taken a break from streaming on my channel every day the way I normally do. I definitely decided I wanted to stream with Tug this week, though, so we're doing tonight, and we're also doing Thursday night. So anything that we don't cover tonight, if we don't get through the entire motion, which I expect we probably won't get through the entire thing, we
I
will
doubt it.
finish it up. We will finish it up on Thursday night. So on my channel. So make sure that you're subscribed here, make sure you're subscribed there, and we will finish it up. But we're starting out with Judge DeThomasis in Florida, and then
You
we'll
want
hit the
you
Laura
want to pull
Owens
that
thing.
up? You want to pull it up?
Yeah, do I have it? Do I have
It,
it? Oh, you still have it there. Okay,
yeah,
good.
yeah. It's
Yeah, yeah.
it's setting. I just haven't pulled it yet.
All right.
It started already too.
All right.
So,
That's fine.
is
It
it
can-
good?
Miss,
Okay.
I've been addressing you as Ms. Mejias. Is it preferable Alvarado, do you go by?
Mejías is okay, sir. Mejías.
Okay.
Yes, it's okay.
All right, Ms. McKittrick, if you can just announce your presence.
Cynthia Munkittrick for the petitioner.
Okay.
Now, Cynthia works for Mark Feather's office. Those of you who've been following the What the Hales trial, Mark Feather is the one that the judge hates, and he's like, 15 minutes, Mark Feather. He hates Mark Feather. So we thought I thought it would be interesting to see how the judge treats Mark Feather's office. This woman works for Mark. And the background of this is that this woman she tried to get a restraining order against her ex-husband, who's sitting over there by, guess who? Attorney Silverman. That's the attorney on the other side. He is representing the ex-husband. She tried to get a restraining order in Puerto Rico. She was denied. She's now in Florida asking for a restraining order here. And it includes allegations of CSA, child SA. And we're going to get to the part where the judge doesn't give a shit. So that's
horrible. That's absolutely horrible. Not just with this, I mean, just period in that system. I do think that this subject ties in a little bit with, that's not necessarily a black eye on the profession, peeping Toms, there,
right.
Yeah.
Right. It's weird how they can divorce themselves from the reality and the horror of the thing they're talking about, like this. So this guy goes and he Judge DeThomasis, the guy in the upper left corner, he goes and he speaks on behalf of a tanning salon perv. You guys have seen the Lego build that I made of the prosecutor who went into a tanning salon and was filming a woman over the top of the booth while she was getting undressed. And 5 judges in the 8th Circuit went and spoke on his behalf at his bar hearing, and he still has his law license, and no one will give me a comment about it. Like the governor of Florida sealed this guy's records. A tanning salon perv, a peeping Tom perv. So, I guess we shouldn't get too, excited that he might care about a little child being SA'd. It's just not really in their wheelhouse. Maybe if she was a prosecutor and the child did it to someone else, they would care. I don't know.
Yeah, like we were saying, if this happens outside of a home, then monsters go to prison. If it happens inside, it fucking frustrates me. Like sometimes I feel like I'm at a loss for words. It makes me so mad. Some of this stuff makes me so fucking mad.
Well, I do think, and somebody said to me today, one of my colleagues at PJ Media, I asked him for a contact in Utah because of this Ruby Frankie thing. And he was like, okay, what are you looking for? And I told him. His response to me was so funny. He said, you really need a different beat that will not affect you spiritually. And I went, you know what? I have felt terrible since Friday, since I went over that Ruby Frankie diary. I have felt sick and in pain, worse than ever. My neck started to hurt me so bad, and I've been in absolute agony since Friday. And maybe that's why. Maybe he's right. Maybe this kind of stuff. I need to but Tug, here's how I feel about it. If I stop paying attention because I can't look at it, because it hurts me to look at it, what about those children who are left in it, who is going to be there to see what's happening to them and to speak for them? Who's
Well,
left if we keep saying, I can't look at this?
well, everybody wants fun cases, and I get that. They want something, but, you know, even those are life records, the people we should be looking at protecting. If we really want, I hate the way the word progressive has been hijacked, but if we're talking about a truly progressive and advancing society, you judge that by how you take care of your most vulnerable citizenry. You take care of your mentally ill, you take care of your elderly, and you take care of your children. So if they're failing on those marks,
We don't do
someone
any of
has to
that.
call it out. No, we don't.
Someone
We
has
fail
to,
it.
yeah, someone has to call it out. And I feel like if I turn around and be like, well, it's hurting me. I can't look at this anymore. Well, it hurts everybody.
Yeah.
It hurts everybody. Somebody has to be able to say, hey, why are we doing this? I am going to contact Utah legislators, and I am going to hold their feet to the fire, and I am going to ask them why you allow child abusers to get one for free. And I am going to ask them, how come you allow a sentencing board to decide these things and give people like Jody Hillenbrand 1 to 15 years in consecutive terms? She might get 60, but she might get 5. You
Right.
know what? Why? Okay. Anyway, we're getting off on this subject, and we're getting off on a rail on the railroad of justice and or injustice, as it
Injustice
is.
for real. That's the true railroad of injustice.
All right. So I gave you the background in this case. It's only 20 some minutes, so we're going to just watch this through because there are some interesting things in here. We're going to pretty much just try and let it play, and then we'll get to the Owens thing after that. Okay, here we go.
Mr. Silverman?
Joshua Silverman on behalf of Luis Gomez Arroyo, the respondent.
Okay. Sir, if you can just identify yourself.
Stand over here. Luis Gomez Arroyo.
Good afternoon. So first issue that we need to address, and it kind of became moot given the finding of good cause for a continuance of the hearing, but the issue of service. And so counsel raised the issue. I went back and researched it further. And the issue raised by counsel at the time of the proceedings on November 10 was that under Florida statute 48.20, the service which was effectuated in this case was improper or insufficient as a matter of law because service in fact occurred on a Sunday and there was no requisite affidavit and predicate to allow such service. Given there was no argument against that position, and the general statute 48.20 specifically does disallow such service, the court then also took into account that the petitioner, through counsel, recently filing a notice of appearance seeking a continuance to allow discovery and otherwise prepare. And so the court granted a request to schedule this hearing for today's date. That being said, the court would bring counsel's attention to 741.30, subsection 8A1, which is the more specific provision regarding service of process, regarding injunctive relief, specifically regarding domestic violence injunctions. And it is clear to this court, and it was not clear on that day, at that time, that this more specific statute controls over the general proposition found in 48.20. And that is that the clerk of court shall furnish a copy of the petition, affidavit, notice of hearing, and temporary injunction, if any, to the sheriff. And it goes on clearly to say, who shall serve it upon the respondent as soon thereafter as possible, on any day of the week and at any time of the day or night. And this statutory provision controls. That being said, we're here December 1 for hearing, and the record would reflect that in fact Mr. Arroyo is present with his counsel and has been served with notice of this hearing, even though it could have been on a Sunday, not on a Sunday, but nonetheless served on November 11, 2021.
Your Honor, you'll recall that at our prior court appearance, when I made the motion or pointed out that I did not believe it was proper service because the petition was served on a Sunday, that I had told the court that in my more than 20 years of practice, I had never made such an argument before and never dealt with that statute before. The court knows me well, knows that I have corrected myself when I turned out to be wrong. I hope the court realizes that I was not intending to mislead the court in any way.
Absolutely. I could advise, when you were making the argument, I pulled up my Westlaw and Shepardized 48.20 and found the cases that specifically address the issue of carving out the exception back when on warrants. The court would say, and can be served on a Sunday, and then they statutorily changed the exception.
Oh my God, this guy. I can't handle it, Tug. I can't handle him with this. Oh, the statutory. This guy, I mean, he loves being the law professor. Like, I'm
Yes, he's not
shocked.
playing the judge. He's playing that is. You would think we were in a mock trial, not a real trial. You would think we were in a mock trial.
Yeah, he's wanting to like, he's like testing the lawyers. How much do you know? Here's how much I know, but how much do you know? We're going to have how long of a conversation about the service? Like, honest to God, like, can we just move on from this? I'm sorry, you guys. We'll get to like some actual like case in a minute. Maybe we should just fast forward through this shit because
And I don't,
this like means nothing. I'm going to fast forward.
Ms. Monkitrick, I also allowed the continuance in the event there was a need for an amendment of the petition. I do not see any amendment to the petition, so are we prepared to proceed on the petition for?
All right, the amendment to the petition might be the CSA, which this I'm going to have to say about Mark Feather's office here. I don't think they prepared her very well for this case. I don't know if they just didn't get this case quick enough or they didn't know, but like they didn't do, I don't think they did much of what they needed to do because it turns out that like whatever technicalities she's going to lose because she didn't have it properly filed or whatever. So
see, that's so messed up, especially when you're talking about a child,
Right?
again, there shouldn't be a fucking technicality that doesn't protect a child. Like that,
Well,
that's
right.
just, oh God.
Thank you for pointing that out because that like I struggle to put it into words like what bothers me about this because it's at one point my law side of the brain is going, you have to follow these laws and you have to put these things, you got to follow A, B, and C. And if you don't follow A, B, and C, well, then you get tossed out. But the other side is like the reasonable side, your human side is like, there should never be a technicality where a judge should hear CSA and go, excuse me, what? What's your evidence? I want to hear it. But
Yeah, I
that's
mean-
not what happens here.
See, otherwise, what is the point in the court? I mean, what really is the point here? I realize that the law is so fucking convoluted that you and I can't step into a court and make it function. That is wrong in and of
Right.
itself. I mean,
Right.
when a child, protecting a kid may cost you tens of thousands of dollars for an essay. I mean, that on itself is wrong. But
And I mean,
again,
I get it. I get like you don't want to be in this. There are women who will accuse
yes.
their partners of false allegations of CSA, and that's a problem too. But what I am about to learn in this case, and what you're all about to learn, is that Florida has statutory laws on the books, and I've tried to verify this with Steve Gosney because he's our local criminal attorney in Florida who knows all these things, and he must be busy because he didn't respond yet, but he will. But according to Silverman, now this is going to blow your mind, Tug, and everybody just hold on to your hats because this is triggering, okay?
All right, here, let me grab my hat. Just hold on. Okay, I got
Hold
it, I
on
got
to
it.
your
I'm
hat.
holding it. I'm holding it.
Hold it. According to what Silverman says Florida law is, and according to what this judge's order says in this case, because I've read the order, the Florida law requires that if a parent like this mother is going to make an allegation of CSA against her ex-husband. She needs to be a direct witness of the event of abuse. And if she is not a witness, it cannot be brought forward.
What?
The word of the child is not enough. Now, that's what they say, and I haven't been able to confirm with Gosney yet if that is actually true. So we may have an issue here where they've said something that is contrary to Florida law, but you're going to hear it in this case, and you're going to see it in the order that I have, where he writes in very plain language to Thomases that she didn't follow, that she can't. Yeah, I know. The chat's like, wait, what?
Yeah.
Listen, I understand how you're feeling, because my head blew off too when I heard this, and I went, that can't be, and I couldn't find it in any Florida law, but it exists in this order that Judge in fact, while we are watching this, I'm going to pull up his order so I can find you the quote of the law, and maybe we can look it up and find out. But I have found, and like I said to Tug earlier today, if you're going to essay a child, it needs to be your child and not somebody else's, because
See,
if it's
that's
your child, no one believes the child, and you have all the rights in court.
yeah. I mean, if you were talking about a stranger, oh, a stranger pulled up and they did this, that, or the other. I mean, my God, but oh, that's so
And you
funny.
also have to have gone to the police. So that's another requirement, is that she should have gone to the police, apparently. So you have to go to the police, but you have to also witness it. What? Well, like, when is the last time that a child abuser abused a child with witnesses in the room?
Yeah. Yeah, I mean, that doesn't that's
That doesn't make
that's
any
the whole
sense.
type of crime. These people operate, I don't even want to call them people. These monsters operate in the darkness. They do, because they are doing the worst. They my God, when we're talking about this anyway, when there's an element out there that the worst of the worst in prisons, they consider themselves better than that element, maybe we should protect children from those fucking monsters. Just maybe there shouldn't be a technicality, where again, oh my God,
But it
that
does
frustrates.
raise the question of, like, how do you keep false allegations from being wielded as a weapon against someone who is not guilty? But if
Right.
I don't know. I don't know the answer to this. But it feels like it can't possibly be,
If you
we don't believe the child ever.
if you can't even hear it, we've seen enough cases where they won't even hear the kid. Like with some of these high profile cases where they're just like, I'm not even gonna hear what they have to say. Like that is wrong. That is wrong. I find myself wanting to say a litany of profanity behind it instead of that is wrong, but it is. I can't stress that enough. If that is a broken law, and
Yeah,
somebody,
that's a broken law.
some people need to be contacted about this shit. Some legislators and ask, hey, point blank. Again, this right here doesn't allow children to be heard. Most of these people run on platforms that deal with domestic violence and protecting kids. That is one of their main platforms. And if they have laws on the books that allow that to be skirted, and the general populace doesn't know about that, that is a huge fucking glaring issue.
It really is. And I feel like you can, I don't know, Tug, like, you're in mental health. You've actually dealt with these cases with
Oh yeah.
children who disclose abuse to you. Do you think that you could figure
Yes.
out what's real and what's been coached?
Oh
Is
yeah.
that something that you are trained to do?
Yeah, you have people that are trained specifically with that. But okay, like you have these crisis areas in mental health, like in the middle of BFE, for example. Those people are not going to be able to go to a person that's going to be able to look at that. Plus, there's the cost and everything else. So they end up with a general mental health practitioner. And I tell you, you sit across the table from some little bitty kid telling you just horrible shit you wouldn't even want to hear from an adult. You can tell, you can see the trauma in kids. Woo. It's
Yeah,
unreal.
I remember looking through the therapy notes of a case I was working on with a little girl who was so very clearly being abused. And in the therapy notes, her therapist is saying, all of these things, her behaviors, and how she's reacting to certain things, and having, and whenever her father is brought up, this little girl was having incontinence problems. Like, she would literally pee her pants when her father is brought up. You can't fake that. And the court gave her to him. And that's one of the ones that haunts me to this day. That, like,
Well,
she, for years, not only did CPS say it was indicated, CPS was on board. They were like, this child has been abused. It wasn't just her mother making the accusations. It was teachers. It was her therapist. It was other people. And yet the judge decided that she should have 50-50 custody with her father, her abuser. And there's nothing anyone can do about it. And if her mother tries to keep her away from this man she knows is abusing her child, she will be
yeah,
arrested.
you're the criminal.
She will be, and there's nothing she can do. And you know what they told her? You know what her guardian ad litem was recorded telling her on a recording? She was recorded saying, well, she'll get over it. You'll give her some, she needs therapy. Get her to therapy and she'll get over it.
I mean,
Not
listen,
that
there
it's
was
still ongoing though. Like, how do you get over something that isn't stopping? And you didn't protect the child. And you tell children that if something is happening to them, they need to say something. And then they say something and no one believes them.
no one protects them either. So if you put them back in that situation, one of the worst cases I've ever seen involved 3 girls where their parents were drug addicts and they were trading them, let's say, for services. They were going to a fairground and trading them with people. And the real horrible kicker, like that's horrible in and of itself. But the real kicker here was the father went to prison for this, but the mother, who was just as guilty, she didn't. In fact, she tried to take her kids. So the kids were put in a home they were adopted eventually, all 3 of them, which props to the people who did that. But the mother tried to take these kids from a school at one time, just all of this stuff, and kept getting slaps on the wrist. And I'm telling you, it's stuff like that. Like, I don't work with kids anymore because it breaks you inside.
It can be horrifying, especially when you realize that the law is not on their side. The law, like in Utah and everywhere else, doesn't give a shit about kids. They really don't. Children are less than human in the eyes of the law. They don't have all the same civil rights that you do. I know you probably didn't know that, but that's true. Children don't have civil rights, and the law treats them like they are less than. And you can see it in the criminal codes, because criminal codes, when it comes to adults for, sentencing guidelines or whatever, it's way higher if you abuse an adult than it is if you abuse a child. The average time that a child rapist spends in prison, and this is from our national numbers in federal cases, is from 3 to 7 years. Child
That
rapist.
dude, so you know the guy, the director of Jeepers Creepers. You
Mhm.
know that movie, Jeepers Creepers?
Mhm.
You know, the horror movie? Okay, well, that guy went to prison for doing some pretty heinous stuff. People can look up the particulars if they want. Well, he ended up serving, I believe, 18 months. And he recorded what
Oh
he
my
did to these
God.
actors. He recorded it, yeah. So he kept making these movies where if you're watching them, you're like, my God, there's
so
something wrong here.
horrible.
I mean, it's all underage kids, and it's this and that. Well, yeah,
Jesus.
it's because he was a monster. So as part of it, he recorded something. Again, it was supposed to be during movie time. He recorded an incident, and like I said, he got 18 months. Not only did he do that, but when he came back, he made Jeepers Creepers 3, and
Ugh.
yeah, that movie, like, people didn't know about that at first. There was this huge blowback to it. But of course, there should be, because people were like, oh my God. And not only that, he put lines in. Like, there was a girl that I can't remember if I think she had been essayed by an older parent, like an older person or a parent, one or the other. And the line was something like, well, you love who you love. And I was like, yeah. And the guy that's making
Oh,
this movie is a predator. It's like, oh my
gross.
God.
Gross. All
None of
right.
these systems protect. I mean,
No,
it's
they
just,
don't. So let's watch one.
anyway.
Not protect a kid. Here
Okay.
we go.
Injunction that was previously filed October 27th.
Yes, Your Honor.
Okay? And counsel for the respondent, are you prepared to proceed?
I'm prepared to proceed, but my client's position and my position on his behalf is that this court cannot proceed on the petition.
Okay, so the issue of res judicata on the issue that was before the court in Puerto Rico,
Okay, res judicata, by the way, means that another court has decided this case, and res judicata means you cannot, if a court, like a legitimate court of the United States, which Puerto Rico would be, has like already decided a case, you can't retry the same case. So that's what they're talking about when they say res judicata.
basically deprives this court the ability to go forward in that the law of the case, the same litigants, same issues, same factual circumstances were previously addressed by another court on the merits. What I don't have before me is a transcript of those proceedings. I do see in the companion dissolution case between the parties that there was an order of the court from Puerto Rico with an interpreter preparing it in English that addresses, the disposition of the case, but not really the factual circumstances that were pled and presented, argued, et cetera.
Your Honor, I do have, courtesy of Mr. Arenas, not this one, but courtesy of Mr. Arenas, the actual petition that the petitioner filed in court in Puerto Rico. It was translated by Mr. Arenas to English, and in fact, Mr. Feather, the petitioner's counsel in the companion post-dissolution family law case, provided those translations to me and to the court by prior email about 3 weeks ago. And I have now provided copies of those to Ms. McKittrick. But in Puerto Rico, Your Honor, if I may approach,
You may.
the petitioner raised the exact same facts, the exact same issues.
Wait a minute. Did he just say if I may approach, but he already approached, or is he going to approach the judge? I don't know, but it felt like he said, if may I approach after he already did it. Who's he approaching? Let's see. Okay, he's going up to the judge. Fine. For a second, I thought he meant the other attorney.
The thick packet on top is where the petition appears, Your Honor. And it's kind of midway through that packet.
How do you have
The first part of
sound?
it is, I think, the temporary injunction.
How do you have sound in a place that is as bad as that is, and yet it picks everyone walking and everything else up? I mean,
That's
yeah,
a very
he's
good
like,
question.
he's like, boom, 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 boom. Yeah,
And the paper shuffling. Why is the
Yeah.
paper shuffling always so loud? And yet their voices can't be picked up well. Court audio is the worst audio in the damn world.
I believe so. Fiona Apple, she started during the beer
Yes.
bug. Yeah, she started auditing, and she brought up a great point about this. So at one time, I believe she was in New York. Like that's where I'm thinking. But again, could have been somewhere else. But I think it was in New York.
No, I
They
think you're
were
right. I think it was New
Yeah.
York.
So she and a bunch of other people were auditing, and they found some glaring issues. And when they pointed them out, instead of the court remedying those issues, the court removed video connection and the audio that
Of
they
course
used.
they did.
Yeah, so
Of course
the
they did.
audio that you hear, it's like you know how the audio is. So sometimes I think some of that's on
Look,
purpose.
in Missouri, where I did my year and a half, it was like a 15-month investigation into family court corruption in Missouri, where an entire circuit court had to recuse themselves because of my reporting. An entire court had to recuse themselves from a case because of the shit I dug up. In that court, litigants were reporting that actual court transcripts were changed because it wasn't open to the public. In fact, I was kicked out of multiple cases in Missouri where I was wanting to be a court observer, but they would kick me out. And then in those same hearings, the litigants would report to me that what was said didn't make it on the record.
That's crazy.
Oh, it happens everywhere though. It
That's
happens
crazy.
all over this country, and the reason it happens in family court the most is because they operate like a star chamber,
Yeah.
which is a secret court, and they don't let observers in. I had a congresswoman, she was a House of Representatives member from Missouri, travel in person to this hearing where this guy had shut me out for days and days, and she listened to me and she was like, "Okay, I'll go. I'll go." She traveled there as a member of the House of Representatives. They wouldn't let her in the courtroom.
Oh no.
And she was like on a panel on the committee for like the Judicial Committee, right?
Mhm.
In Missouri. And she's like, you have to let me in. Like, I'm a representative of the House. The legislature, by the way, has the authority to oversee the judiciary. That's their job. That's when you talk about checks and balances in the
Yeah.
judiciary, it's the legislature. They are the boss of the judiciary. They wouldn't let her in the room, Tug. And you know what's unbelievable about that? Instead of going back to the Capitol and starting impeachment proceedings against that judge, she just forgot about it. Never did anything else about it. She was like, "Oh, they wouldn't let me in. That's weird."
Yeah. Next thing, hey, maybe don't I have a basket to weave or something?
It's just so crazy. It's just so crazy that like an actual sitting member of your, your representative can go and be locked out of a court hearing, and literally it's a secret court and you're just like, "Oh, ho hum, I guess I got to get back to the Capitol and do my work." It's so weird. But that really happened, folks. It really happened. I mean, I know the chat's like, "Oh my God, what?" And like, no, it happened. She called me on the phone. She's like, "I don't know what to tell you, but they won't let me in the room. They kicked me out." I'm like, "Why did you leave?" Like, why did you leave? Why weren't you like, "I'm a representative of the people of Missouri and I demand to be in this house. Like, I demand to be here in this room. Like, nope. She just left.
Yeah, you would think. See, if you were serving the people, that would be a big issue. You bring it to the people, and the people would be appalled by that. But that tells you these folks, they're not serving the people.
If that were me, if I were the representative and I got shut out of a courthouse, I would call the press immediately from outside the courtroom. I'd call them and have them meet me at the courthouse.
Mhm.
And I would tell them, "This judge will not allow me to witness this family court case. I'm here as a representative of the people because the people told me they're concerned about this and I want to see what's going on. And I'm being kept out by these bailiffs, by these sheriffs who have no right to keep me out of this courtroom." And I just tell the people through the press, but they don't do that. They don't use their bully pulpit. They don't. And then I would go back to the Capitol and I would start impeachment proceedings against that judge. I would absolutely start impeachment because they have the right, but they just don't exercise it. It's crazy. What was her name? Oh, I've forgotten now. I will have to go back through my records to find it. I'll remember who it is eventually. The reason why I didn't go like nuclear on her was because she was one of the only people who cared enough to actually try. And I kept thinking that maybe she would continue to try,
Right.
you
Yeah,
know?
you didn't want to burn that down without knowing what she would do.
Right. I didn't want to burn it. I mean, I felt like, well, she understands there's a problem, right? So I gave her some time and clearly she's done nothing about it. So maybe it's time to burn it, I don't
Yeah.
know. All right, here we
Was
go.
issued by the magistrate of the court in Puerto Rico. And so let me get to it, Your Honor.
So Silverman's really prepared and the other attorney is not prepared at all. She's reading that thing like she's never seen it before. She's literally reading it for the first time. And Silverman knows what he's doing here, and he's the judge's favorite, as we all know.
All right, so it's about 6 pages in, and it says top of page 6, and then it went through, it says on August 28, 2021, the court issued an order for protection under the following findings of fact.
I'm with you.
And it recites the findings of fact that the court made in that petition, which reflects what was in the petition. The petition appears a little bit later on the next page, where the allegations are. If we look at the petitioner's allegations, she states as follows. On June 22nd, 2020, Luis Gomez attacked me at home in Spring Hill. We had an altercation. He took advantage of the moment in order to hit me with his head and push me backwards with his head and screaming at me to leave the house immediately. When I threatened him to call the police, he screamed at me and threatened me by saying that if I called the police, that I should be aware of the consequences. When I tried to hide in the room with the baby, he followed me screaming at me to open the door. He was able to open it and told me that he wanted to see the baby girl, and he asked me what I was going to do, threatening me that if I called the police, I had to leave the home. He squared off in a position to fight me and told me what, pushed me hard against the closet. The child was right next to me. I fear for my safety and of my daughter. He is an aggressive person. He has PTSD, keeps firearms, would threaten me and his children, Nick and Nathan, constantly, that if we reported him, they would take him to jail. In this petition that's before this court today, she talks about that incident in Spring Hill. She talks about the threats. She talks about the PTSD. She specifically mentions my client's other children, Nick and Nathan, and the threats and violence he perpetrated upon them. All of that is contained within this petition. Contrary to what Ms. Mejias stated in her petition for an injunction in this case, the injunction in Puerto Rico was not dismissed based on jurisdictional matters. It was dismissed after an evidentiary hearing on the merits because she was unable to prove, by competent substantial evidence, the elements of an injunction in the territory of Puerto Rico. The two smaller packets I provided to the court are the translations of the judge's ruling in Puerto Rico. There was an evidentiary hearing, and
Let me, on that issue, because that was another, I guess, piece that was pled that was somewhat, I'm going to use the word misleading, but I'm not ascribing intent, that it just misleading in that.
Mistaken.
What was represented is that it was dismissed on procedural grounds. I'm not saying that that was done with intent to mislead the court, but it might be just a misunderstanding.
well, Your Honor, if you look
Is that
at
in the petition? Is that where that came from? Where did the information?
if you look at the disposition, which is one of the smaller packets I provided,
Now, you're correcting the record with why it's dismissed, or is this going to show that it was on jurisdictional grounds?
it was not on jurisdictional grounds.
It was not, but where did that come from? Initially, somebody alleged that it was on jurisdictional grounds.
I believe it was in the petition in this case, Your Honor.
Okay.
And I can pull that up.
I'm looking at it right here. That's what I was. Gotcha. Under subsection Roman numeral 3, number 1, as pled by the petitioner, when the inquiry was made on the petition itself, has the petitioner ever received or tried to get an injunction? Answer in the affirmative. And then it reads, in Puerto Rico, they dismissed it because of the jurisdiction.
Correct,
So
and that was not the case.
It was, what you're saying is, these documents
Show
would,
those.
in fact, establish that it was substantively addressed by the court, and it was a lack of.
If you look at the second page of the thin packet I provided, second of 2 pages, it states as follows. Having reviewed the court file and based on the evidence presented, the following findings of fact are issued. Having listened to the evidence and having evaluated its credibility, the elements are not proven under Law 54. Consequently, a denial is being issued in regard to the protective order, and its archiving is hereby ordered. The petitioner must file the corresponding civil action related to the custody case with the competent superior court. These documents, which, by the way, were provided to the court by her lawyer in the other case, the companion family law case, clearly show that she pled the same subject matter, the same facts in Puerto Rico. There was privity of parties. It was petitioner versus respondent in that case, same petitioner, same respondent in this case. It was the same subject matter. There was the same motive and opportunity to develop and cross-examine evidence in that case as here, because the allegations were identical. On the merits, the court in Puerto Rico dismissed that or denied the injunction, or protective order as they called it, because she failed to meet her evidentiary burden. That is the textbook definition of an adjudication on the merits. Pursuant to the full faith and credit clause, as well as probably about 150 years of Florida history and Florida jurisprudence, she cannot get a second bite at the same apple simply by going to another jurisdiction and asking this court to do over what she already lost in Puerto Rico. That is simply not permitted. Now, I will concede, Your Honor, that there appears to be at least one factual allegation in this
Yeah, the CSA.
proceeding that as far as I can tell, was not raised, or at least was not raised by the pleadings in Puerto Rico, and that is some kind of allegation that my client sexually abused the party's daughter. However, there's no evidence of that. If they want to have a hearing on that today, fine. We can have a hearing on that one limited issue. Certainly nobody's going to be repeating child hearsay in this court, and there's no...
See, child hearsay.
Child hearsay.
You hear that? Certainly no one is going to be repeating child hearsay in this court. So if the only evidence you have is your child's testimony, you don't get to say it in this court.
That's wild. I mean, that is...
Shall we continue?
corroborating evidence, and there's no evidence for any of those allegations.
What evidence would there
save the
be?
alleged statements of them.
Like, what evidence would... I'm sorry, I can't stop myself. What evidence would there be other than the witness testimony, the child's testimony? No, I mean, those of you saying, well, it's Florida, this is how it is everywhere. I hate to tell you this, but this is how it is everywhere.
Minor child. So if they want to go forward on that limited allegation, we could certainly do that, but I haven't the slightest idea how they would go about proving that, and I would submit to the court that they cannot.
Ms. McKittrick, first off, if you've had a chance to review the documents, which the court has now reviewed, it does appear, aside from, and we're going to address this separately, aside from the current petition filed before this court, which does include allegations attributed to the minor child made against this respondent. Other than that, it appears that the same parties involved with the same subject matter, same factual circumstances have been pled previously, and the court in Puerto Rico literally evaluated the credibility of the evidence. The elements of the offense were not proven, and so clearly engaged in a full adjudicatory hearing on the merits and ruled contrary to your client's position. So if there's disagreement with that analysis, and whether this court would be stopped really from going forward, as it is the law of the case, it's raised judicata on the issue, what would be left then would be the allegation, which appears to be not included in the Puerto Rico petition, which involves the minor child alleged complaint. And if I'm correct, let me just double check, this petition is filed, yes, by the petitioner and by the petitioner on behalf of the minor child. It raises a couple other issues, some of which Mr. Silverman has kind of addressed, which is the proof issue on the minor child. But let's just first deal with the res judicata issue on what was pled and what was resolved.
Your Honor, this is the very first I had seen or heard of this. I was going by what my client had filled out in her pro se petition. If we could skip this for about 10-15 minutes so I could talk to her out in the hall and kind of discern what's going on.
Okay. Mr. Silverman, I'm inclined to give her the time to review that. So
I have no objection. I'll point out that I got these from her lawyer, or her other lawyer, but I have no objection to passing this.
Right. So, but when you say that, the record should reflect, and the court is aware, Ms. Mejias Alvarado is represented by counsel, Mr. Feather, in the dissolution proceeding, Ms. McKittrick in the case that's currently before the court here today. So I'm going to give counsel that's present an opportunity to consult with her client. It may resolve the issue, but while you're consulting so we don't break again,
what happened?
You boomered it. You boomered.
No, I didn't touch anything.
Oh, did it go black when they went out or something?
I don't know. Anyway, they take a break. So let's just get rid of that. Remove from studio. They take a break. Nothing else happens in that one. And then I think the one that comes back with his explanation of what they're going to do, I have here. Hold on, all right, video file.
It's just crazy how dismissive it all is about, the kids hearsay evidence, their voice. Their voice doesn't matter, And again, I get it.
It's unfortunate that her attorney did not get all the information it clearly took her attorney by surprise. So she didn't have whatever it was that Silverman had. And look, we don't know. I don't know this family. I don't know these players. I have no idea if this is a false allegation or a real allegation. I don't know, but it disturbs me that
Yeah,
a
I mean,
judge is like, well, I'm not really interested. Like, the law says this, and so that's what we're going to do.
this judge bends over backwards for another party that we see, and quite literally finds exceptions to make sure that they can do whatever the fuck they want in a courtroom. Meanwhile, you're talking about a child, and it's just, well, that hearsay evidence.
Yeah, right. It's child hearsay. Hey, we had to get over that in the Kowalski case too, by the way. Her journal was they were going to call it child hearsay, but it actually overcame the child hearsay laws, which is maybe something we should look into. Like maybe those are laws we don't really need. Child hearsay. Like how old does a child have to be before you believe them? Or before
Right.
their voice matters? And here we had Maya Kowalski, who is by all accounts a precocious child, an intelligent child, a way beyond her years child, and she was keeping a journal in that hospital where those awful people were doing bad things to her, and she was keeping a journal, and they almost didn't let that into court. Like, what? Why? Because of child hearsay. I did and that was Florida too, by the way. I looked that up, and there were some things that overcame child hearsay, and in that case it did. But, maybe we should relook at these. All right, I pulled up the next one. I think this is the one where he gives his order and his explanation.
All right, the record should reflect we're back in session, 38-2021 DR 543. Ms. Mejias is now present with her counsel. She's been given an opportunity to contact her counsel in the dissolution proceeding, as it might overlap with her decision-making here in proceeding today. Ms. McKittrick?
I think, maybe I'm reading wrong, but Ms. McKittrick had told me that there was going to be a voluntary dismissal coming, but it appears that's not the case anymore.
Apparently not, sir.
Which actually serves my client's purposes better. I'd ask the court simply to dismiss this and find that it's res judicata.
All right, so let's not get out of sync here. So, Ms. Mejias, yeah, if you could sit next to Mr. Arenas so that if there's any issue of understanding.
Is her lawyer ever going to get to
proceedings.
talk?
So the
It
issue
doesn't
with
seem like it.
regards to res
Is she-
judicata,
Is she going to put up a fight at all? I mean,
Ms. McKittrick, have you had a chance to evaluate that after consultation with your client?
Your Honor, I do want to state for the record that my client has, and this was today truly the first time I have seen this, but my client somehow understood that it was dismissed due to jurisdiction, so she truly did not understand. That
I'll
being
accept
said,
that.
there is one additional incident that happened more recently that she prefers to proceed on.
Well, what
what?
would that be?
Okay, this is where I have a problem. Oh, shit. Tug, can you still hear me?
I can.
Okay, good. My computer's having a problem, so I'm going to let you read some super chats while I reboot, and I'll come
Okay.
back in
Okay.
because it's definitely going to kick me out in a minute. I'll be back.
Okay. Oh, that's
All right.
All right. I'm going to hit some super chats real quick, and then Megan's going to reboot. So here we go. All right. Bad Duck. Thanks for the 2 there. Quack, quack. Quack, quack indeed. Thank you for that. Let me pull down the video thing until Megan gets back to. Sarah Green. Thanks for the 2. No statement, plenty of statement. Thank you. Blind Lawyer Explains. Thanks for the 2. Tug's favorite word is y'all. That's co-opting. That's co-opting here. Come on. That's a microaggression. Trey, thanks for the $5 super chat or super sticker there. Thank you. Appreciate that. Scott Roberts, thanks for the 10 there. Walking around coins for candy. Candy time. Thank you. Captain, what's up, Captain? Thank you for the 5 gifted memberships. I saw this fall in earlier. I didn't see the thing pop up there, so I appreciate that. Thank you. Lonely, what's up? Thanks for the 10 there for demonetization fund, indeed. Indeed. Somebody asked, by the way, like, yeah, I saw a question in the chat asking about having a problem letting them do whatever they wanted to this guy. They didn't do anything. They didn't even listen to the new issue here. There was a case. You had claims that were made in a case minus the claims by a child. Now, you should at least hear those. You would think there'd be something in that system that would hear that. I mean, again, if you can't protect a kid, what can you do? What's up, Megan? You back?
I'm back.
All right, let's see. Let me hit a couple more of these real fast.
Yep. No,
Nick,
get him.
thanks for the super chat there. I'm awake, shouldn't be. Have a man cold, can barely breathe, need to whine. It's
Oh,
4:75.
Nick, I'm so sorry to hear you have a man cold. Are you wearing your bonnet though? If you're wearing your bonnet, you should drink a hot toddy. Have the woman make you a hot toddy. You'll feel better soon.
Hey, it was a good break time anyway, because
Oh, here comes Bug.
Hey, you want me to open these? Is this a cheese stick?
Yeah,
You got some cheese sticks?
yeah,
Here
because I
come the
put my
kiddos.
finger. I like it.
You like cheese sticks, huh?
Yeah, she said.
Okay.
I
Well, this
like
thing's-
rocket pops. We ran out of rocket pops.
Yeah, I know we're out of Rocket Pops. I know that.
Isn't
Get
it
away.
funny how
Yeah,
dads
yeah.
and moms can
We
interpret
run
what
it out.
Yeah. Well,
what
you
they're
get used
saying.
to it. Yeah.
We ran out of your milk.
We ran out of normal milk. Okay.
We have more left.
Wait, how do we have more left, but we ran out? I'm confused.
Just 2 left with more.
Okay. Yeah, that didn't
Okay.
really answer my question.
I'm gonna touch you with these teeth.
She said there's less and there's more. I was like, what does that mean?
Aw,
More milk.
No. Okay, and here's your third one. All right.
it's
take these
funny how
upstairs. There you go.
you learn what your toddlers are saying,
I
and
use-
no one else can
I
understand it
took out my
except you.
milk. I want more.
One more milk.
I
You
could
got acidity
I
points
could
on it.
interpret for my youngest son,
Yeah, you're the best dad ever.
Yeah,
and it
mine-
sounded
Yeah,
like
that's all right.
gibberish to everyone
Keep
else.
the milk. Keep with the milk.
Well, go
I
get the glass and the milk. Hey, I'm gonna go get some milk real quick. Can you talk?
No,
for
go
1
ahead.
second?
Of course
All
I
right.
will.
All
Of
right. Hey, I'll be
course.
right back. All right.
Yeah, go get the milk. She's so funny. Oh my God, she kills me. All right. So, for those of you who are just catching up, we are watching Judge DeThomasis, who's in the What the Hales case, on another case, totally unrelated, which has Silverman on one side and Mark Feather's office on the other side to see if, does he behave the same way? I will give him this. His demeanor is not as offensive to Mark Feather's counsel. Now, Mark's not in the room, so maybe that has something to do with it. Like, is it because Mark Feather's not in the room that he's being more polite to this woman? I don't know. But for those of you who are just maybe tuning in, we are going to get to Laura Owens and the new motion filed in her case by her new attorney, who is going scorched earth, and it is insane. And we're almost finished with this too, so we're going to get there soon. I'm actually looking through the order that DeThomasis wrote in this case, and I don't know much about this case. I don't have a side. I haven't taken a side. I don't know the facts in the case, but I do know that Mom has made an allegation of CSA. And instead of finding out what are the details of that allegation, DeThomasis has just completely decided to ignore it.
All right, I'm back.
Oh, good. Hey,
Yeah,
I was
that
just
was.
catching up anybody who's been here, who just got here recently, to what we're doing.
Okay. Yeah, I was ordered into the. Give me some more milk. I was like, okay.
Man, that one drinks a lot of milk, by the way. She's
Yeah,
always on
well-
you about, give me more milk. That
Yeah,
was
it's
my
that,
ki-
it's
was
that
my
time right
kid.
here. Yeah, that's the time right here. It's a specific time at night. She's like, hey, I
Mhm.
want a little bit of milk. I've been good all day. Let's have some good stuff.
She's 4, right?
Yeah.
My baby, my littlest one, who is now, oh my God, he's going to be 10 in August. I can't even believe it. But I let him stay on the bottle a lot longer than the others, because he's my baby. But he was like a little terror with that milk, man. He was always like, he wanted that milk all the time. I miss those days. Dang.
My oldest is 10 right now, so 10 and 4, and it's like, wow, you know, they're funny. It is funny though that you can translate. Like I can translate her sister between me and her sister. Sometimes I'll hit a word, especially if I'm driving. You know, I'm like, I can't understand what you're saying to me. You know, what are you saying? And her sister can translate pretty much anything.
Isn't that something? The kids
It-
always can.
Yeah. All right, let's hit this.
All right, so now we're back to the beginning
All her
because
personal property at my client's
to
home when
redo
she took the child and went.
All right,
there was
here we
a
go.
car that she.
It's,
It's not alleged in the petition.
it's not alleged in the petition.
all right, we got to go
stored
back.
at her ex-husband's house.
What's the date be?
Your Honor, apparently, she had her vehicle stored at,
Okay, wait, we got to go back.
more recently, so she truly did not understand.
Okay, there we are.
That
That's where we
being
were.
said, there is one additional incident that happened more recently that she prefers to proceed on.
Well, what would that date be?
Your Honor, apparently, she had her vehicle stored at her ex-husband's house.
What's the date of her most recent
What is the
accusation?
actual date of the tire incident?
October 29th.
October 29th.
Of this year?
Yes, Your Honor.
It's
Not alleged in the petition.
It's not alleged in the petition.
I know what she's referring to. Apparently, so when she got back from Puerto Rico pursuant to this court's order in the dissolution case, there was a car that she was awarded or went to her as part of the dissolution, and she also left all her personal property at my client's home when she took the child and went to Puerto Rico. So she asked to arrange to get that back, and the car's just been sitting there for like 9 months, 10 months, and it had some flat tires. So apparently she alleges that my client slashed the tires on the car in his own driveway.
Even if that were true, if that
It's
was
not
alleged in
violence.
the petition, which is not, that would be a property crime of criminal mischief and not a domestic violence incident pursuant to 741-282. So even if that's true, even if it can be attributed to the acts, and I'm not attributing them to Mr. Gomez Arroyo, I haven't heard the case, but even if it's true, let's just assume that's the allegation, and even if it's true, it's not an act of domestic violence as defined in the statute. And so if that's the only additional fact, based on the respondent's motion through counsel to dismiss this action based on res judicata, the court having received and reviewed the English version of the court ruling, the court does find that the same subject matter, the same parties, the same factual circumstances were raised, except for the potential issue regarding the minor child. However, that's a matter that would need to proceed under a separate statute.
Here we go.
Clearly cannot proceed under the domestic violence or prevail today, based on what really would amount to solely hearsay of a minor child.
No.
Additionally, and we're not getting to this issue, if we got to the issue, what is alleged in the petition, and it's part and parcel of why there's a hearing without a temporary injunction, is that there was no basis to find any imminent threat of harm, because we've got an issue of remoteness in time, and that we have allegations that may be construed as prior acts of domestic violence, but even if so, they would be remote in time. And thus the court is going to dismiss the petition previously filed in 38-2021 DR 543. And that would resolve this matter and leaves open the other matters contained in the dissolution that I'll address with Mr. Feather and Mr. Silverman once we can have a status conference. And I'm sensitive to your time constraints. Everybody's got them, especially now we're at a crunch. But at some point, we're going to have to at least discuss what can we address and needs to be addressed more immediately than the other parts.
I understand. And as to December 13th, Your Honor, I'm in mediation that afternoon. I think it's at my office. If Ms. Hagan were to call my office and say that you need to speak to me, I can step out. Ms. Mack can step in.
All right. What I'm hoping to do is, at a minimum, give you guys a heads up that that time has freed up, and then you guys could evaluate what best might work in the week of January, that first week of January.
Yes, sir.
Thank you, Your Honor. That concludes my business. May I withdraw?
Thank you. You may. Appreciate you being here. Senor Arenas, thank you for your assistance.
All right, so that's it. So he rules against her. He never hears any of the circumstances. And I don't know about you, Tug, but if I'm the judge on the bench and someone's in front of me saying there's an issue of CSA, I'm like, what happened?
Yeah, he's assuming the time frame on it. He assumes a lot when he was talking about it. There was a lot of assumption. Well, this may fall under prior, and oh well, if this stuff falls under, this falls under prior. I'm like, what the fuck, man? I don't know. I find it all disgusting. And again, when you look at this, all right, if we're gonna say this judge, letter of the law man. Well, why isn't he a letter of the law man when we're watching current cases? Why does this happen like this? But I mean, I've watched again
or is the law so bad that he didn't have a choice? I don't know, but and that's what I'm trying to.
He just wings it though. I mean, when it comes to like the Hale case, I mean. There are things are not appropriate. They're not appropriate. And the letter of the law doesn't matter then. So it's just fascinating when you're talking about the potential for child safety. And yet I am very sensitive to the idea of false allegations as well. The problem is we don't even hear what happened.
We don't even hear the facts of the case. Like, we're not hearing it. It's not. And is it because she didn't understand what are the processes she's supposed to go through? And if that's the case, I kind of blame her attorneys for not, filing whatever needs to be filed so that she goes through those right motions. But if it's really that the state of Florida requires a witness to child abuse when one parent is accusing another, I'm sick about that. That's absurd. No parent who's a child abuser is going to do it in front of the other parent. That's never going to be the case. So you have to actually witness it. What are you supposed to do? Set up nanny cams? I guess you could.
Yeah, so you're supposed to distrust even when there's cases of abuse, like spousal abuse, people don't think, oh my God, kid. Like, again, we all have these ideas that people operate with that proverbial line in the sand. They have the same lines we do, and they don't. People don't. But you have to get to that point. And again, if there's all these fucking hoops that a kid has to jump through, a kid's not going to be able to do this, And we have all these systems in place that are supposed to help. And like I said, I keep getting stuck on the idea. Lynette, if we're talking about properly filed stuff, I mean, I've seen what counts as evidence, and I've seen what counts as motions in that case. And yeah, no, not at all.
I mean, he didn't even hear what she had to say, right, about the CSA. And yet in his order is real. Here, do you want to bring that up?
Oh, yeah.
Let me see. Present, share screen, window. I have to walk myself through this. And in his order, there you go. In his order, he is just under no circumstances or for no reason shall either party remove the minor child from the state of Florida without an explicit written order of the court. I mean, her story is that she took the child to Puerto Rico because of this problem. I don't know why it's doing that. Look at what's happening on the screen. Yeah, that's so weird. I don't know why it's doing that. I'm not even seeing that motion to qualify part, the half and half. That's so strange. I don't know why that's happening.
That's weird.
I don't see it on my actual screen, but I see it on yours, which is bizarre. But I mean, he's like, his language is very, I don't know, what's the word? Aggressive against mom and towards dad. So basically, dad is entitled to his time sharing. You better not take this kid anywhere else. She's in contempt. Look, he found her in contempt. Former wife is adjudged to be in indirect civil contempt of Florida's relocation statute because she took the child to Puerto Rico. But he never even heard. He never even heard why. He wouldn't listen. So I'm
Well, the
I don't
problem is
know.
all these mechanisms that are supposed to be there, like DHS or CPS, all of that, they will default to that order. So they will not do anything unless it's a brand new thing. So essentially, somebody could get away with something horrific. They could put a child in custody, and we've seen this stuff go wrong. And again, like I said, I'm very sensitive to the idea of false allegations too. But we didn't even get to allegations. We didn't even get to that point. He
No, we
told
never
you.
even got to it. And that's the problem. It's like we don't even know. And in all the documents I have about this case, there isn't one document that lays out what the allegations are. And so for all we know, and here's a woman, her English is not her first language. She had a translator in court. You saw that.
Mhm.
It's not surprising she misunderstood something or didn't it's not surprising. And I think that more time should be given in a case where CSA is alleged, just to see, like, well, it needs to be heard. We should hear it. We don't just dismiss it out of hand. And that's really, it seemed like that's what happened. So I feel like that's a problem. And it did seem that Silverman was like, he was so on his game and like he totally had all of his arguments. And her attorneys, unfortunately, didn't. They were caught with their pants down, hadn't seen something, didn't have an argument. Her attorney never even made an argument. So we can't say that Judge Thomasis was biased towards Silverman because the other attorney gave him nothing.
Right.
Like literally gave him nothing. And that's unfortunate. I'm sorry to see that. I would have liked her to have stood up and said, hey, Your Honor, the allegations in this case are really serious and we need to have them heard. But she didn't. She was like, well, there's the issue with the car. Like, what? You've got a child saying that she suffered some kind of abuse and you don't bring that up to the judge? Like, I don't know. All right. Anyway, moving on. I think that's enough of that.
I just, like I said, when I compare it, again, you jump through hoops when I'm looking at the current stuff. I mean, he basically, he becomes the lawyer in that. It's not like he's teaching a law class. It's like he's representing
Totally.
Lynette. And, you know, he finds ways to allow things in. But in an instance like this, I don't know. I really want to get a hold of that Peeping Tom case.
Right.
I really do. I want to see what's there sealed.
Well, it's all sealed by order of the governor, and so we're not allowed to see it. All right, what some of you may have been waiting for a while, I'm about to pull up on the screen. This would be Laura Owens' new motion that her attorney has filed. I don't know if we'll get through all of this. We have, although it's kind of early. It's only 8:42 my time. All right. You can pull it up anytime.
Oh, sorry. I zoomed in. You talk about booming. I was like, okay, it's about to come up, and I full screened out. I was like, wait a minute.
Now, I am personally not going to mention this attorney's name because I feel like he really wants to be famous. He has written, is very clear. He has written this motion in order to get as much attention as he possibly can. And I don't feel like giving it to him, so I'm not going to talk about him in particular. I will say this, though. He is not a family law attorney. He is a defamation attorney, which I find very interesting. She had to have paid him a substantial amount of money to take this case. He is the 13th attorney that she has had on this case. And I think she had to have given him, if I had to guess, somewhere between 30 and 50 grand retainer to do this. And he is going scorched earth. So let's get started because it's nuts. This is a motion for extension of time to respond to respondent's motion to compel. You will remember that the last motion from Greg Woodnick was a motion to compel evidence that she alleged she had during the deposition, including photographs of her alleged miscarried twins that she did not give to the defense. Pursuant to Rule 4B, Arizona RFAM petitioner Laura Owens, Ms. Owens, or petitioner moves the court for an order granting extension of time to respond to the motion to compel filed in this matter by respondent Clayton Echard. On March 11th, 2024, good cause exists for this request for multiple reasons, as discussed in full below. In addition, and for purposes of clarity without an extension of time, petitioner's response to the motion is currently due today, April 1st, 2024. For the reasons stated below, petitioner respectfully asks the court to extend her response date for 10 court days, meaning if this request is granted, the new response date would be Monday, April 15th. Okay, that's my birthday, by the way. April 15th. Tax day. I'm a tax day baby.
I'm a month right off that for May.
Are you?
Yeah. Uh-huh.
On the 15th also?
Yep.
No, shut up.
Yep, indeed.
Of May?
Yep.
May 15th?
Mm-hmm.
That's kind of interesting, Tug. Look at us. We're birthday twins. Like
middle month babies. That's what it is.
Middle month babies. Introduction. On its face, this should be an incredibly simple and straightforward case. Yeah, it should have been. It should have been. That's right. Ms. Owens claimed that she had sex with Mr. Echard in May of 2023. She claims she had a positive pregnancy test on June 2023. Unfortunately,
she lied.
Okay. After efforts to speak with Mr. Echard about his intentions were unsuccessful, Miss Owens, she sent him 500. Let's remember the facts of this case, folks. She sent him 500 texts and emails. She also tried to get him fired from his job. She went to the board of the, we have to remember the actual facts of this as we read it, because this guy is going to try and gaslight us to believe that none of this actually happened. Within 5 days of hooking up with Clayton Echard, she went to the Arizona licensing board for his real estate license, you guys, because whatever, he didn't put in her offers or whatever, while at the same time saying, you need to date me, sign this contract. Okay. Initially, both parties were unrepresented by counsel. As sometimes occurs with pro se litigants, Ms. Owens made a handful of motions that an experienced lawyer would have advised against. You can say that again. Those motions were quickly denied with no meaningful impact on Mr. Echard, who once again was pro se. I don't know how he can say it had no meaningful impact. I think we'd have to ask Clayton about that. In late September 2023, the parties agreed to submit samples for genetic testing. Unfortunately, those tests were inconclusive. No, they weren't. 2 of them came back little to no fetal DNA.
Yep.
The third one was lost in transit, and the 4th one she refused to take. So the two that were taken and read said little to no fetal DNA, which means she ain't pregnant, is what that means.
Mm-hmm.
So it wasn't inconclusive. That's a lie. Unsure of what the next steps to follow and without counsel to guide her, on October 18th, Ms. Owens filed a 2-page form requesting mediation. Although Mr. Echard never responded to or opposed this request, on November 22, the court issued a minute entry order denying the mediation request as premature. At some point around this time, Ms. Owens claims her pregnancy ended with a miscarriage. Well, that's weird, because that would be October, and she was in court on November 2nd claiming she was 100% pregnant with twins.
We're also that's a lot of fast forwarding and skipping a lot of detail in the middle there.
It sure is.
Yeah.
At some point around this time, you're going to have to do better, Laura's lawyer. Do better than that. As at some point around this time. How about a date? Are you telling me that a woman who passes 2 fist-sized sacks from her vagina doesn't remember what date and time that happened? Bullshit. I call bullshit on you. Miss Owens claims her pregnancy ended with a miscarriage. Concurrently, there was a significant collateral litigation between the parties, which resulted in protective orders, harassment injunctions being entered against both, preventing Miss Owens and Mr. Echard from having any direct contact, based on a lack of case activity, which was hardly surprising given the paternity issue was by then entirely moot and both parties were unrepresented. No, but she didn't tell anybody it was moot. She didn't tell anyone that she had this until December 27th, by the way. It was December 27th when she had the motion filed that she had that she was no longer pregnant. So he's saying that it was moot before December 4th, but that's not true because she was still claiming she was pregnant. On December 4th, 2023, court administration issued a notice advising the case would be dismissed for lack of prosecution if no further action was taken. If nothing else happened, this would have resulted in the dismissal of this case with no legal fees incurred by either side. But something else did happen. In mid-December, Mr. Echard retained counsel who appeared. I'm not actually sure when he retained the counsel, but it was before mid-December, because it was at the November 4th hearing that he had counsel. November 2nd, sorry. So he's wrong. His dates are wrong. Oh my God, fuck off. Your
Well, with this
dates
case,
are
I
wrong.
mean, you expect truth anywhere. You know what I mean?
I know, but I didn't see this in the first read through. I'm just going through
Oh
it
my
now on the second read through, and things are standing out to me. I have to make a note of this because this is right here is just like absolutely ridiculous. Sorry, I have to grab my notebook. What is this? Line 25, page 2. 25, mid-December. No, he had counsel before that. He had counsel at the November 2nd hearing because that woman, I will never forget it. I covered that hearing and I was like, oh my God, she's like the reincarnation of Johnny Depp's lawyer, Camille Vasquez. She was fantastic. She was so good, that woman. I'm not sure if that was Isabel or if that was somebody else, but he had counsel on November 2. So it was not mid-December. Mr. Echard retained counsel who appeared and immediately began accusing Ms. Owens of fabricating her pregnancy. Well, she kind of did. Mr. Echard moved for Rule 26 sanctions and has filed a recent fusillade of other offensive motions. Oh my God. Don't start on what's offensive, sir.
Really?
I'm offended by Laura Owens. I'm not offended by anything Greg Woodnick has done, including the motion to compel at issue here. As explained below, given that Ms. Owens is no longer pregnant and there is no other immediate exigency, good cause exists to grant a short extension of time for Ms. Owens through newly retained counsel undersigned to respond to the motion to compel. Before those reasons are explained, it is important for the court to understand the broader context of this case. Oh, please explain it to us.
Yeah,
Just
I really need that. Yes, let's.
mansplain it, please.
Oh my God, I see the Trump is.
Oh yeah. Wait,
Oh
it
my.
gets crazy. It gets crazy. If you have not
Oh,
poured yourself an alcoholic beverage, you're going to need to do that right about now, because we're about to get into the Trump derangement syndrome that is her new attorney.
well,
And by the way, he has a Twitter account, and it is insane.
you know, this is also we saw this in the Depp case too. You know, when they were shopping accusations, that's what they did. You know, they threw it all into a body of work. That article that's exactly what it was. It was Orange Man at the end, and it's like, what the fuck does that have to do with anything that you're saying? Anyway,
This gets so crazy. You're gonna wonder what this man's mental health is like. Okay. And I can tell you by looking at his Twitter account, which I do not feel like telling you about. Like, don't make him famous, okay? Because this guy there's something wrong with him. His Twitter account is full on Trump derangement syndrome. And it's so bad he can't keep it out of this motion. That's how bad it is, as if this has anything to do with Trump. But here we go. Here we go. Here we fucking go.
Oh, Lord.
This action arises under circumstances that, when viewed in full, may start to sound eerily familiar to another legal matter that also recently made headlines: the case brought against former President Trump by columnist E. Jean Carroll. Indeed. Excluding only the allegedly pregnancy. Oh, dude, get an editor. The alleged pregnancy, not allegedly, alleged. So he also can't, he wrote this in a fury. So the Trump derangement syndrome took over as he was writing this, and like he didn't even go back and fix his mistakes. Excluding only the allegedly pregnancy doesn't make sense of Miss Owens. A fact not presented in Carroll, thank God for Donald Trump. Both cases are closely analogous. Oh, are they? Or are you just like, does he live rent free in your brain and you can't think of anything else?
This explanation is gonna be wild. I can just see it now.
I told you it was. I told you.
Oh.
I told you. Guys, make sure you hit that like and subscribe button if you're just hanging out and you didn't do that yet. Make sure you do that because this is about to get wild and crazy. Miss Carroll's story is, like the instant matter, very simple. Miss Carroll claimed in the 1990s that she was sexually assaulted by former President Crump. I said
Crump. Crumpet. Yeah, you got so stuck on allegedly. You're like, oh my God, Crump. What's up, Crump? It sounds like a rapper. You know? What's up, Crump?
Isn't that a dance move? Crump.
Crump's gonna
I
drop the
can't believe
bass.
I said President Crump. That's so funny. Was essayed by former President Trump in a department store dressing room. Miss Carroll did not sue Mr. Trump at the time, nor did she publicly disclose her allegations against him. You know why? Because it was bullshit.
Bullshit.
Years later, Ms. Carroll published her story about Mr. Trump in various articles. Mr. Trump responded by accusing Ms. Carroll of fabricating the entire thing. Plaintiff Carroll publicly accused defendant Trump of sexually assaulting her in the mid-1990s. Defendant, who was the president of the United States at the time of the accusations, denied plaintiff's claims in a series of public statements. In the first release that same day, he claimed that it never happened. He never met plaintiff and that she is trying to sell a new book that should indicate her motivation. The next day, he stated that this is a woman who has also accused other men of things. It is a totally false accusation. Carroll v. Trump. After Mr. Trump accused Ms. Carroll of lying about the essay, Carroll sued Trump for defamation. Notably, due to the amount of time that passed, no physical evidence existed. By the way, this is his explanation for why Laura Owens can't provide any evidence, even though this thing happened, she says, in 2023. So can I point out that there's a big difference between something that happened in the 90s to something that happened literally last summer?
Yeah, and we're talking about, again, pregnancy. You know, I mean, there's a big difference versus claims of essay. Again, you're talking about 30 years old.
This is crazy. No physical evidence existed to support Ms. Carroll's assault claims. There was no DNA, no rape kit, no medical records. In short, the only evidence Ms. Carroll had to support the alleged assault was her own testimony, corroborated by a few friends she told at the time. Based on that testimonial evidence, limited as it was, a jury found Mr. Trump did in fact SA Ms. Carroll. Yeah, because the jury was out of its mind. Period. And that he defamed her by accusing her of lying about what happened. I don't know how any jury could find in those facts that he definitively did something, but that's another story for another day, but whatever. This resulted in an award of damages to Miss Carroll of nearly $900 giggity dollars. Like, I don't know. It was so many billions, billions and billions and billions. Oh, I have a button for that.
Billions and billions and billions and billions and billions and billions and
of dollars. See, judge approves Trump's $92 million bond to cover jury award in defamation case. So what on earth? I love the way this guy writes. This guy, he's doing that. And if you haven't noticed yet, he's doing this for this purpose. He knows that this case is being discussed in the media and he wants attention.
Yep.
And so his entire motion is filled with unprofessional bullshit that it gets so crazy, you're not even going to believe it. Now, I will give Greg Woodnick some props right here. Greg Woodnick's motions are spicy, but they have never been unprofessional. Never. Like,
they deal with the case too, with the elements of the case itself. This has nothing to do with anything.
No, this has nothing to do with anything. And like, he even knows it. So what on earth does Carroll v. Trump case have to do with this matter? I have an answer for you, sir. Nothing. Nothing. Okay? Nothing. But the way he writes is so juvenile. It is, I've never seen a lawyer do this ever. I've seen people who think they're lawyers write like this, like pro se litigants, sovereign citizens I've seen write like this. I have never seen someone who owns a bar card write like this in a motion that goes before a judge. I just want to say that before we get to the worst of it. This isn't the worst of it, folks. It's still coming.
Phrasing?
Okay. The answer is this. The underlying theme of both cases is functionally identical. Here, Miss Owens claims she had sex with Mr. Echard and she claims she became pregnant as a result. The only main difference from Carol. Oh, you mean it's not a main difference that there were 30 years between the allegations and the lawsuit? Because that seems like a pretty big difference to me, sir. In return, just as Mr. Trump did, Mr. Echard now furiously in red.
Yeah, I like you. Yeah, I like you put that in a different color.
I've seen bold before, but I have never seen a different color font before. He released this, by the way, on his website, unredacted, with emails, unredacted, from Greg Woodnick, which outed Matt Mulvey. So he either did that as a scorched earth thing, like where he doesn't care, or he didn't notice. But he did it, and it's pretty awful. Okay,
Either
it's
way, I mean, either way, it's still awful.
It's awful. In return, just as Mr. Trump did, Mr. Echard now furiously claims Ms. Owens fabricated her entire story, just like Mr. Trump. Mr. Echard claims. So he's likening Clayton Echard to Donald Trump, you guys. Do you see how insidious this is? He's trying in the media to liken Clayton Echard, of all things. He is so far left, that dude. He's so far left, he can't even say the words, women sometimes lie. Like he can't. He's like, I believe women. I believe women. He says it over and over and over again. He believes women. He believes me too. He knows that that's an important thing for him. Even though he's being destroyed by a woman, he still won't say Me Too is garbage. But this guy is going to put him, now it doesn't matter. He's Trump. He's Trump.
Yeah, well, I mean, that's the thing they do, man. It doesn't matter. It doesn't matter if you're part of their club. It doesn't matter at all. I mean, once you get that bullseye on you, you become a devil on the other side.
Wonder when he'll wake up to that fact. I don't know if he will, but this should help. Just like Mr. Trump, Mr. Echard claims Miss Owens must be lying because of other past allegations Miss Owens made against other men, a gambit also used by Mr. Trump, which the jury flatly rejected in that case. Although in this case, we actually have the men, sir. We have Michael Maricini and Greg Gillespie, and we have their court documents that prove she did this again and again. And now we have Matt Mulvey, who we don't know if he has the balls to step forward and actually talk about it, but he should. By the way, folks, Matt Mulvey is on Twitter. You can find him there if you look hard enough. He's on Instagram too. And he needs encouragement, positive encouragement that says, we believe you, you will be supported, but you need to speak out. You cannot sit behind your lawyers in your $1 million mansion, and watch other people's lives be destroyed while you are safe and protected by your wall of lawyers. That's not the way this works. It's not okay.
Well, he hasn't been protected so far, has he? I mean, these people.
Well, his silence has not protected him, no.
Yep.
Which is what my email to him said. Your silence hasn't protected you, but it will harm the others in front of you. I'm so angry. There is another parallel. Oh, look, there's another parallel. Here we go. Here comes the worst part. Here comes the worst part. But there is another parallel with Carol that this court may not be aware of. During her recent deposition, Ms. Owens testified, Mr. Echard arped her. Look at how it's said as a statement. She claimed he forced schmexual intercourse with her against her will and without her consent. Okay, Tug, we're going to do a dramatic reading of this. I will be the A, you will be the Q. You ready?
Okay, here we go.
I told my sister that Clayton had, I guess, stuck his penis in when I told him not to.
Wait a minute. You're claiming that you told your sister that you told Clayton not to put his wee-wee inside you, but he did?
Yes.
Are you suggesting that Clayton arped you?
That's technically a definition.
Technically, what? But your testimony right now today is that Clayton had penetrative sex with you against your will.
He stuck it in when I told him not to, yes. Okay.
The
For a
fuck?
second, can we just stop here for a minute? Because this is not taking into account, and if I'm, Clayton's attorney, I'm going to be publishing again that email that she sent him after this event, begging him to have sex with her.
Yeah.
Begging
Date
him.
me.
And I'm the safest person you can have sex with because I'm already pregnant. And if you would just have sex with me, you would see how tight I was. That's what she said in her email. That is not ARP. Okay? Like, that is not, there is no way. And look at how her answer, you're suggesting that Clayton ARPed you? That's technically a definition. Yeah, it's a definition, but are you suggesting it? You're saying it? Like, I wish he had kept on with that. Are you saying that's what happened? Because her attorney is saying that's what happened, but she didn't say that's what happened.
Man, you talk about deflection because of everything else that came up in that. They're like, hey, let's find a straw to grasp at. Hey, here's one with barbs on it.
This is insane.
It is. That's fucking crazy.
I got so mad when I got to this part. The first time I read through this, I was like throwing things.
Do you remember though? Okay, when we first talked about this, I was like, what's the over under for when she actually accuses him of rape? And we were like, surely that's not going to happen. I was like, sooner or later, man. I mean, so many of these go that route.
Well, also, I want to point out that her sister so far has stayed out of this and doesn't respond to, lawyers' requests or anybody else's request to talk to her. But she's now going to get subpoenaed.
Oh, yeah.
Because she just said that she told her sister this. And I don't think her sister can stay off the stand now.
I know.
Because if I'm Clayton's attorney, I'm subpoenaing her sister right now. Because this is crazy. No, her sister will come forward because she'll be compelled by the court to come forward. She has no choice but to come forward. If you send a subpoena, you must show up or there's a warrant for your arrest. Her sister has been named and she needs to show up now and answer to this. And her sister has been named twice now, not just in this, but in I sent my sister the picture of the fetuses. Her sister needs to show up now, and I'm tired of the excuses of, oh, she's my sister and blah, blah, blah. Your sister's a psychopath. Get on the stand.
God, I mean, life wrecker.
And now, can we look at this? Aha? What?
Aha!
Aha! But no exclamation point, though. A period? Aha. What?
Mm-hmm.
Aha. Aha. What the actual F is going on here?
Well, he crossed that. Look at that next line.
To save respondents' counsel the trouble of screaming, redacted, saying it clearly. Like, he's just doing this. He's doing this so that we will read this and find it funny. But I don't find it funny, sir. I find it disgusting and juvenile and amateur. I find it amateur. To save respondents' counsel the trouble of saying it clearly, this allegation is contested. Mr. Echard has, or presumably will, categorically deny that he ARPed or essayed Miss Owens. Mr. Echard was deposed before Miss Owens, thus he could not and did not respond to the ARP allegation in his deposition. Well, he couldn't because he didn't know it existed.
Right. Yeah, because it's never been alleged before. This is something that just popped out of the woodwork.
Yep, just came up in the deposition. When viewed in this full context, the picture here becomes clearer. Mr. Echard has vociferously, angrily, and repeatedly tried to paint Ms. Owens as a compulsive liar, a crazy person who made up fake pregnancy allegation in a sad and desperate attempt to trap him into a relationship. Sounds pretty accurate.
Yeah.
While these facts obviously remain strenuously disputed according to Ms. Owens, what is happening here is something entirely different. Mr. Echard is taking a page directly from the Donald Trump handbook on how famous men should respond to rape claims. I'm sorry, did he write a book about that? Is that real, or is he making that up?
I don't seem to remember him publishing any books of that name. I think that would have made the media, you know.
And I'm sorry I said the R word again, but
Oh,
it's
well, it
hard
doesn't
for me to
matter.
read.
I have a habit of it, but after what we've covered in this
I know
today, you
we're
know,
going to get
it doesn't
demonetized.
even
I'm
matter.
sorry, Tug.
No. I mean, these are important topics. Unfortunately, a lot of people won't cover things that are important. Again, no shots at anyone. I get that. At the same time, this stuff should be covered because these are life ruiners.
I'm just looking it up just in case someone wrote this book, like as a satire. I'm just to, I'm dotting my I's and crossing my T's.
Watch, the lawyer wrote it himself.
So I looked it up, and all I came up with are CNN and Vanity Fair headlines. So, yeah, no, there's no book of this name. He's making this up. I don't know why, but yeah, he's just making it up.
Could you imagine? My eyes would get stuck if I were a judge, rolling them back into my head.
Right. You're also taking kind of a risk in Arizona by doing this
That's
because
true.
the judge might be a Republican.
That's true.
Might be. I'm not saying is, but might be. And if you are using it's kind of irresponsible, in my opinion, to bring in like firebomb sort of politics into your motions, because you don't know how the judge is going to react. You don't know what their politics are. And that's a risk. And frankly, I think it's kind of a risk he should not have taken. He should have found actual case law about other things that are less, divisive, maybe. But look at this, i.e. deny everything, smear the accuser as a lunatic and a liar. I don't know, but don't you guys think that E. Jean Carroll is kind of a lunatic and a liar? I found her to be that. I don't know what's wrong with that jury, but I found her to be very strange. Wasn't she the one who said ARP was a fantasy? Women fantasize about ARP? She said it on CNN.
She had a bunch of quotes that, came up during, I don't know, that, just making this period. I mean, period. It has nothing to do with this case.
No, it has nothing to do with this. Claim they made the whole story up and hope no one believes her. In fairness to Mr. Echard, obviously someone is lying here. Yeah, it's your client. The question is who? It is possible Mr. Echard is telling the truth and that he, unlike Mr. Trump, is the victim of a totally false claim. But at the same time, it is also possible, as occurred with Miss Carroll, that Miss Owens is the one telling the truth and Mr. Echard is lying and smearing her in a disgusting attempt to cover up his misconduct. Now, this is my favorite part, folks. Hashtag me too. Hashtag me too.
What?
Not hashtag me too. Hashtag me too. What is this guy, a boomer? No, he's my age. He's actually a couple of years older than me. We were actually at ASU at the same time together. I can't even believe it, but we were. Who writes this like this?
Well, like you said, he has a Twitter account and everything else. You'd think he knows how to use hashtags.
You would think. But I think I really like the spelling out of the word hashtag and then adding it to hashtag something.
I just putting that in a document period. Like what does that mean? I mean, I see
don't even know.
He's tried. I think this is all for weaponization for other parties. That's why you put it on a website. You get the media to pick it up. You get all
this
these
isn't
other
for the
people to pick it up.
judge.
No,
this is for the media.
This is you have a courtroom and then you have the court of social media. And that's where this is supposed to play. Mhm.
And that's why she hired him. He is an internet lawyer. All of his cases are defamation cases between people online. So he fights for, and strangely, and you're going to laugh at this. This is so funny and it's so apropos, really. So his Twitter bio, let me go on to his Twitter real quick. Trust me, guys, if you want to know who he is, just go to the Reddit page. You'll find out. I'm just not going to say his name because I refuse to give him more attention. His bio on Twitter says, internet lawyer, willing to fight for your right to speak even when you're 100% wrong. What?
Well, it just shows you it just shows you how the courtroom works. That's one of the things that I was ranting about the other day. That really bothers me with lawyers. Lawyers, they will make, in my opinion, indefensible arguments. They're like, hey, everybody has the right to representation. Sure, but I've seen some absolute monsters in courtrooms being represented by people that they know they're monsters. They know that they are monsters. They know they have done just horrific things. And they're like, paycheck, baby. I'll defend you even though I know you're wrong. It's like
he advertises it. I'll defend you even if you're 100% wrong. I don't know if I go into law and I go and I get my law degree and I'm like, that was actually something that I might have wanted to have done. I wouldn't have gone into law because I wanted to fuck people up with the law, I want to go into law because I care about the law. I want to uphold the law. I want to hold somebody accountable to the law, not use the law to get scumbags off. He's literally on Twitter saying, I will defend your right to say whatever, even if you're 100% wrong. So you're a defamation lawyer admitting that you'll fight for anybody if the paycheck is good enough, even if they're wrong. No, that's not what most people go into the law for. You might go in as a defense attorney to give someone a robust defense because that's what our Constitution demands. And so even the worst of the worst deserve a defense. That I can respect. But nobody goes into the law going, I want to get murderers off. Nobody.
Well, they usually try to hide that. That's why you have I'm a mafia lawyer. You know what I mean? They have code for it.
I want no milk cans. I can't reach the bottom.
She can't reach the bottom of what?
She can't reach the bottom of her cup here. She has a
Again, it's a milk dilemma.
Yep.
Again with the
She's
milk
like, can't you turn it up and drink out of it? Or will it won't work?
Yeah, if you turn it
I'm gonna
up,
go
it's
fix her
in-
cup real quick. She has a
You
cup
go fix
dysfunction.
the
All right,
cup.
I'll be right
Go
back.
ahead. Bug invasion. Yeah, I don't understand someone admitting and advertising that I will do things nobody else does. People don't, you wouldn't take a case if you got if the client who comes to you and you realize that they're 100% wrong, you wouldn't want that case. Who the hell wants that case? This guy wants it. And as we go through this, you're going to see that it just is, yikes. All right, well, moving on. This is, of course, why court exists. He really needs an editor. This is, of course, why courts exist. Yeah, that's okay. That one works. To resolve disputes and determine the truth in a fair and reasonable manner. But that process takes time. Well, how much time, sir? We've been doing this since she filed in July. I think 7 months, 8 months he's been in court. How much time does it take to discover if someone's pregnant or not? And it requires careful investigation of all the evidence and all the facts, not just half the story. I don't know. I think we have all the facts because he's not going to give us anything in the next couple of pages that we haven't already seen. With these preliminary points in mind, good cause exists to grant Ms. Owens a brief extension of time to respond to Mr. Echard's motion to compel. Accordingly, this motion should be granted. A. Good cause exists due to a change of counsel. Filed concurrently herewith is a declaration from undersigned counsel explaining a few key points. First, the undersigned was first retained by Ms. Owens on Monday, March 25th, 1 week ago. Prior to being retained on this matter, the undersigned did not know Ms. Owens and had no prior knowledge about the parties or this dispute. Accordingly, the undersigned is literally starting this case from scratch. Well, that's too bad, because you take the case as you find it, sir. That's the law. You take the case as you find it. And it doesn't matter if it's going to trial in a week or a month or a year. You take the case as you find it. So you're whining about you're new. Oh, you're new. Oh no. It's really illegitimate. You take the case as you find it. And by the way, the court isn't until June 10th. So you've got plenty of time. Plenty. Immediately after appearing in this action on Monday, March 25th, the undersigned contacted Respondent's Counsel and requested a call to meet and confer about numerous issues, including the pending motion to compel. A copy of the preliminary message sent to Respondent's Counsel is attached as Exhibit A to the declaration submitted herewith.
I'm back, by the way.
You didn't miss anything except for him starting to whine that he doesn't have time to take this, to respond.
The little one just picked up some fun. I was telling her, hey, go on. She was like, I'm going in front of you up the stairs. And I was like, okay. I was like, go on, man, go on. She was like, she turned around. She was like, I'm going. Jesus.
Jesus.
Jesus. It's like she's talking about Kanye West, Jesus.
Jesus. I love it.
Anyway.
I love it. A lengthy hour-long telephone conference between counsel occurred on the afternoon of March 26, 2024, followed by extensive email discussions about the case, which he's going to attach to this filing. After that call, Respondent's Counsel graciously and promptly provided copies of numerous but not all case-related pleadings, documents, evidence, and other things. Copies of case-related correspondence between counsel were not provided. Ms. Owens also provided the undersigned with some, but not all, case-related materials. In an effort to gather a complete file, on March 27th, the undersigned contacted both of Ms. Owens' former attorneys who appeared in this case. The first was Alexis Lindvall, who appeared on December 22nd and moved to withdraw just days later on January 2 after taking a new job in Texas. The case was so bad, she fled to Texas. The second was Corey Keith, who appeared in this case on January 11th and withdrew on March 12th. Yeah, again, couldn't hack it. Unfortunately, neither Miss Lindvall nor Mr. Keith responded to the initial request for a copy of Miss Owens' file. As a result, a follow-up email was sent the next day. Later that same day, a different attorney from Miss Lindvall's firm responded to say that she, Miss Lindvall, left the firm to take a job in Texas to get as far away from Laura Owens as possible.
She's like, yo, I'm leaving. I'm not leaving the state. I'm leaving the entire firm. I'm
leaving the state.
I'm out of this sucker.
This person stated they believed Miss Lindvall had provided Miss Owens with a copy of the file before leaving, but Miss Owens disputes this. Well, I would question that because she disputes a lot of things that she can't prove. Fortunately, the undersigned was later able to reach Mr. Keith by phone on the afternoon of March 28th. Mr. Keith confirmed he had not yet provided Miss Owens with a copy of her file, but he promised to do so later that day, Friday, March 29th. As of the filing of this motion, nothing further has been received from Mr. Keith.
So they threw all the lawyers under the bus too? Wow.
Yeah. Standing alone, the fact that Miss Owens recently had to change counsel, once through no fault of her own, as a result of her prior counsel, Miss Lindvall, leaving the state for a new job, should provide good cause for a brief extension of time to respond to a pending discovery motion arising from matters before current counsel appeared without a complete copy of Miss Owens' file, which has been diligently sought but has not yet been attained, it is not possible to respond to the merits of Mr. Echard's pleading. All the other issues aside, this should be sufficient for the court to grant the requested extension. Oh, but wait, he is about to go into all the reasons why he shouldn't have to be in court at all. So this motion is so disingenuous, because if it was really about, I just need till April 15th to respond to the motion to compel, he could have ended it here. But no, we're going to keep going, and it gets crazy. Tug, do you want to read? I feel like I've been
I
speaking for
can.
too long.
I can. Here we go.
All right.
Good cause exists because respondent failed to comply with Rule 9C. A second and even simpler reason exists to grant the. Give me a second. I'm gonna full screen this. Okay, here we go. A second and even simpler reason exists to grant the present motion because Mr. Echard's motion to compel fails to show a good faith or any effort to resolve the issue in manner required by Rule 9C. The language of the rule is clear. Quote, when these rules require a quote-unquote good faith consultation certificate, certificate. Okay, my bad. I was like, wait a minute, is that right? Yeah, okay. The certificate must demonstrate that a party has made a good faith attempt to resolve the issue. The consultation or attempted consultation required by this rule must be in person or by telephone, not merely by letter or email. So they're playing.
Wait. They absolutely tried several times to resolve this. Greg's on the record as sending her and her lawyers messages that say things like, all your client has to do is admit that she perpetrated this fraud on my client, and we will move on. We will not ask for attorney's fees. We will not ask for anything. And we won't do anything. We will let you drop this case, but sign this document that says you falsified this pregnancy. It was never real. And she has refused to do it. How is that not good faith?
That's so crazy. I mean, and it's like, well, you never caught us on you never caught me by telephone or in person. So, technicality.
Right.
Here, the certificate attached to Mr. Echard's motion makes a vague reference claiming his counsel spoke to Mr. Keith, quote unquote, regarding petitioner's outstanding disclosure on 2 dates, February the 2nd, 2024, February 21st, 2024. Beyond that vague reference, which does not explain whether those conversations involve the same issues raised in the present motion, there is no explanation whatsoever. The font changes describing what was discussed, what disclosure remained outstanding, and how, if at all, that information was later provided, such as in Miss Owens' subsequent deposition, March 1st, 2024.
We have the emails. We have lots of them between Greg and Keith about how he's missing all this stuff. There are several of them. So I don't know what he's talking about or if he hasn't seen those emails, but they exist.
It just popped in. He's like, we need more time to do this. But by the way, I know everything.
Right. By the way, I know that you didn't do this and you didn't do that. Like, yeah, he did. And there's emails. So, okay.
The certificate also refers to one email sent to Mr. Keith, March 4th, 2024. That's Exhibit 5 there. That email raises some points about discovery containing mostly argument. Of course, a single argumentative email is, per se, not sufficient to comply with Rule 9C's requirements of a direct lawyer-to-lawyer discussion in person or by telephone. Again, underlined, not merely by letter or email.
Well, so how is he determining? How do you find out if Greg spoke to Keith and how many times on the phone? I'm sure he did speak to him on the phone, but like, is there a record of that? I don't think the attorneys are recording their phone calls and keeping them for the court record. It's absurd.
Apparently, I guess you should with these people.
Yeah, I mean, it's absurd. Like he's totally going for this technicality thing, like not merely by letter or email. Well, did he talk to Corey and find out how many times they spoke on the phone before he decided to accuse Greg of not following Rule 9C?
It's just grasping at straws again. Rather than bringing a discovery motion one day prior to the withdrawal of Mr. Keith, who presumably would have told respondent's counsel about his intent to withdraw sometime earlier, Rule 9C required Mr. Echard's counsel to make a sincere, good faith effort to talk with petitioner's counsel in person or by phone before seeking relief from the court. That clearly did not occur. I feel like we just said that.
That clearly didn't occur here. How do you know?
Well, I mean, didn't they just say that 3 times?
Yeah, it's. I don't know how he knows that clearly.
He gets paid by
didn't occur
word.
here.
He gets paid by the word.
I think he's making a mistake, by the way, by going in this hard in this court where he's never practiced in front of judges he doesn't know, and against an attorney who's been in this same court for 25 years. I think he should be careful about the type of allegations he makes against another attorney and a good standing member of the bar who teaches ethics classes. Like, honestly, like, be careful.
Look at this next sentence. Look at this allegation. Obviously, the withdrawal of Mr. Keith likely suggests he was either unable or unwilling to speak to respondent's counsel.
Yeah, I don't think so.
Yeah,
I don't think like, we didn't really go after Corey Keith very much. We made fun of him a little bit for like his body language in court, but like I felt sorry for the guy. I really did. I felt sorry for him. He was like starting a new firm, and like he had the misfortune of his very first client in his new firm to be Laura Owens. I felt very sorry for him. And from everything that like I could see, like it seemed like Greg Woodnick was trying to work with him, and like I don't think there's anything about Greg Woodnick's behavior in any of this that makes me think, oh, that guy doesn't play well with others. No way. He's been a practicing member of the bar for 25 years in this family court. He's very well respected. I think I've told you guys, my sister hired him 10 years ago. We found that out throughout this. He's very well known in that area as being a very good lawyer. I think this is a mistake. But let's be quiet and let him make his mistake.
Yeah, exactly.
I think Greg Woodnick is very well liked and very well respected, and this is a court he's in all the time. And I think, yeah, Woodnick called Corey his colleague and friend all the time in his emails to him. He was like extremely polite and reaching out to him and trying to. He even said it in court. He was like, my colleague and friend. This is a guy who has class. So I think I would be careful going after Greg Woodnick. I don't think he has a lot of enemies, is what I'm trying to say.
Well, I mean, what other card did they have to play, though? I mean, really, like when you get down to it, what else is left besides nastiness and what I at least perceive as dirty tricks?
Well, let's also not forget that Laura sent an ex parte email to one of the judges in the cases accusing Greg Woodnick of plotting to kidnap and ARP her. I wonder if her new attorney knows that she accused another attorney of kidnapping and ARPing her. So,
I mean, all this stuff is mental. This is the unfortunate reality. This is the unfortunate reality of what happens in attorney-client relations end. But rather than allowing respondent to take unfair advantage of this fact by giving short shrift to the good faith requirements of the rule, the court should instead require counsel from both sides to strictly comply with Rule 9C's good faith requirements. For whatever it is worth, undersigned counsel immediately sought to meet and confer with respondent's counsel.
Yeah, you're a real saint.
Yeah, what a great guy. I love it.
You're such a great guy.
In an effort to resolve all pending discovery disputes.
Where are the pictures of the fetuses? Where are the pictures of the fetuses? Why don't you hand those over?
Well, like he says here, he's like, of course, the process takes time, especially in a case as complicated as this one.
Yeah, it's not that. I thought he said at the beginning it's not complicated at all. It's a simple case. Didn't he?
Yeah, it's just like the old man. Come on, man.
Wasn't that the first line? This is a simple case. Well, now all of a sudden it's complicated by line 15.
It's a
We're
complicated, simple case, don't you know?
It's a complicated, simple case.
Oh, hey, you're cutting off a
Woo.
sentence there. Yeah, roll down just a little bit.
Did I? What did I
Yeah,
do?
yeah, 16. Yeah, there it is.
Oh, there we go.
Thus, good cause exists to grant an extension of time or to summarily deny the motion because respondent filed the current motion without first making a good faith effort to resolve the discovery issues with opposing counsel as Rule 9 requires. Now we get into, oh my God, here's another playbook. The motion to compel appears to contain false or misleading statements which require time to investigate and address. A third independent reason establishes good cause to grant a short extension of time to respond to Mr. Echard's motion. That reason is as follows. Again, taking a page from the How to Smear and Defame a Female Essay Victim playbook.
Which doesn't exist. Again, and he's changed the title of it this time. So this is just some fictional book he thinks
Well,
exists.
Mr. Echard's lawyer should respond with, you're actually taking a page from the well-known book, Destroy a Man Now, which is a real book.
Yeah, I mean, this isn't a real book, How to Smear and Defame a Female Ex-Abuse Victim. I mean, come on.
Mr. Echard's motion contains numerous specific allegations claiming Miss Owens lied about the facts of the case, and even worse, that she has done so in a manner which shows not just accidental mistakes, but calculated, intentional fraud. Yes, that's been from go. That's been the allegation of this from go.
Look at this. Keep reading time.
Let's be specific. After starting with a gratuitously insulting rhetorical statement that, quote, compulsive lying is not a defense to disclosure production. Oh, so dramatic. Mr.
This is so unprofessional. I have read so many legal documents over 20 years. I've never seen anything like this. Did the universe just give us this guy?
This does sound like pro se. It really does.
It does. It sounds like a sovereign citizen. Like, who is this guy? And why does he? Well, for one, he's not he's a defamation lawyer. Which again,
it seems like it's meant to play with the media. I mean,
of course.
It doesn't, because I mean, this kind of stuff.
What this is.
Presenting it to a judge, you're like,
People on Reddit are like, was this guy drunk? Did he write this when he was drunk? It has that flair. I'm not suggesting he was drunk, but it to me reads like somebody who this is like the first draft you write, and then you go back through and you take out all the emotional stuff that you really don't want in there, but you get the emotional stuff out on the first draft. Man.
I mean, you should be able to remove you should be detached from this. I mean, he just popped in. Like, he doesn't have any stakes in this whatsoever. He was paid to come in, and right off the bat, bam. So the emotion there. The question
is, maybe the stakes he has in it are tied to some serious money. The only way I can think of that anyone would want to take this case is if she offered a gigantic retainer. And the only amount I could think of that would make it worthwhile to do this is like 30 to 50 grand, maybe.
I mean, you maybe you want publicity, even if it's bad publicity,
right?
Like, hey, if you're in a hopeless situation,
he wants his name out there. He wants to be famous, which is why I refuse to say his name, because I think that this is insane. I think this is crazy. And to put, so dramatic. I got to show this to Nick Rekieta. I just hit me that Nick has to see this. I have to show him this. I have to take a screenshot of this exact line and send it to him like immediately, because this is insane.
Yeah, you need to tell him, like, man, this case, it's got his name all over
I
it.
tried to get him involved in this case so many times. I'm like, Nick, it's got everything you love. 2 blowjobs in one night, tonsil twins. You can't get better than this. And like he just didn't take the bait. But maybe he will now with the oh so dramatic.
Yeah, it's
Who
showing
is this guy?
the orange man freaking stuff.
I know with the Trump stuff, it's
Yeah.
insane. Can you imagine Nick reading this? Oh my God, he would tear this guy to pieces. It would be
Oh,
so funny.
I think it would be hilarious. I think he would enjoy it.
I think
Mr.
he would enjoy
Echard,
it too.
listen, Mr. Echard makes a specific statement that appears to suggest he discovered proof Miss Owens lied about every aspect of her pregnancy and that such lies have been confirmed by third-party medical providers who verified Miss Owens was never treated by any of them. Quote, notably, of the litany, 14 plus provider names given through petitioner's testimony prior to her deposition, multiple providers have denied providing care or overseeing / communicating with petitioner. And it tells where that came from. So,
Okay, but again, let's also notice that it says of the litany of 14 plus provider names, multiple. It doesn't say a number. It says multiple providers have denied providing care. Okay. All right. Moving on.
yeah, they're saying, hey, we did talk to some. But so let's be blunt. At first blush, this allegation sounds really bad for Miss Owens. Mr. Eck, at first, like, yeah, Oh, I see
It
the
does.
yikes down at the bottom too.
Uh-huh.
I feel like
Oh,
I'm typing on Twitter here.
it's
Mr.
so
Echard's,
crazy.
it does. It seems like social media communication. Mr. Echard seems to say that at some point during the litigation, Miss Owens was asked to provide the names of every doctor, medical provider she saw. And after giving those names, Mr. Echard's counsel contacted each to ask if she was in fact a patient at the facility. Mr. Echard then states, quote unquote, multiple providers, implying all providers. And it does not say all providers.
No, it
says
doesn't say
multiple.
that. So I don't think it implies that at all.
No. Confirmed that Miss Owens lied about being a patient. Yikes!
Yikes.
Yikes! Oh my God.
Yikes. No, so he didn't imply all. He literally said of the litany of 14 plus provider names, multiple providers have denied. Multiple, not all. The word multiple means more than one. And so, no, it didn't imply all. Nope. And so this next sentence is absolutely false.
During those discussions, Mr. Echard's counsel.
Wait, no, you missed one. To be clear, we're at 14.
Oh, my bad. It rolled up. Yeah. To be clear, the statement is, at the very least, intentionally, seriously misleading, if not outright false. Here's why. Immediately after appearing in this case, undersigned counsel began the process of meeting and conferring with respondent's counsel in an effort to understand exactly why discovery disputes exist and how those disputes could be resolved. During those discussions, Mr. Echard's counsel made numerous representations about the current state of discovery / disclosures. 2 central themes in those discussions arose. Number 1, a claim by respondent's counsel that Miss Owens has, quote unquote, no medical records that support her fake pregnancy narrative.
Let's
So
go
that's
to the
number 1.
footnote on line 27 down here.
Okay, this statement was made by respondent's counsel in an email sent to the undersigned on March 27th, 2024, and they attached it with Exhibit B. Okay, so we have a date on that too. Okay, and number 2, a claim that every single provider contacted by respondent's counsel confirmed that they have no records relating to Miss Owens, which, if true, would strongly suggest Miss Owens fabricated her entire story. But are those points true?
As for number 2, notice he doesn't have a footnote with his source.
Mm-hmm.
So the claim that every single provider contacted, is that this?
It's supposed to be referring back, I think. Yeah.
Is that this? Notably, the 14 provider names, multiple providers have denied. Well, that fails because he didn't say every single provider. Nope. And also, as to footnote number 1, no medical records that support her fake pregnancy narrative, that statement is true. There are no medical records that support her pregnancy narrative other than the HCG tests, which have from the beginning Both Mr. Echard and his counsel have said that's not enough. We need more than a P test because it could be her meds that she's on. She could have got it from the horse dealer. They have HCG for horses or whatever. Who knows? She's a horse girl. She can get horse medicine. Who knows how she fabricated those, but she could have. And by the way, pregnancy tests that are P tests are only a sign of pregnancy. They are not a proof of pregnancy. Once you get a positive P test, you have to go to a doctor and get a blood test. We have never seen a blood test from Laura Owens. So the sentence, there are no medical records that support her fake pregnancy narrative, is true. I do not accept, and nobody else should accept, an HCGP test as evidence. No one should accept that.
Here's another question. How many doctors need to be like, yeah, we never saw her at this place at all before that presents her lying?
You're gonna see what his explanation for that is, and it's insane. It's
so naturally,
insane.
okay. I've got to see this. Naturally, such specific and serious allegations raise immediate concern. If true, this would appear to prove Miss Owens lied about the facts of the case. If true, this would require the immediate withdrawal of undersigned counsel.
Okay, wait, Tug, do you have super chats to get to? Because speaking of pee tests, I need to pee.
Okay. Yeah, I can hit a few. Uh-huh.
All right, I'll be back.
Okay.
Chat, if you have to pee, people in the chat are like, I need to pee. Like, go pee quickly.
Go to the bathroom. All right, here we go. Let's see. Theresa, thanks for the 5 there. I always support you. So here's some groupie cash, Tug. I'm really amused by that phrase, if you can't tell. I think that's a hilarious statement, by the way. And thank you for the support, too. Also, thank you as well, added to that, gifted membership. I love gifted memberships. I think that's one of the best features on this platform. Ness, thanks for the 21 months. Cindy Love from Germany. Hey, love return from here in Tennessee. Appreciate you. K-Rap, thanks for 5. Really enjoy when you and Megan stream together. When you laugh together, it's extra funny. Yeah, I like streaming with Megan. That's why we do it often. You know, it took a while to get there, but I'm like, hey, you know, I want to stream with somebody. I'm going to have Megan on. Tracy, thanks for the 2. Oh, good. We're getting a law lesson again. Yeah, when you looked at that video, exactly. Chance NP, thanks for the 10 there. Appreciate that. In Virginia, child abusers are frequently not charged with abuse, but with other charges where the Commonwealth attorney can get more time because child abuse laws are weak. And that's sad. It is absolutely terrible. You know, you would think that protecting a child again, that would be important, but Tracy, thanks for the 5. Ah, yes. Believe all women, but not child. Exactly. Great. I live in the craziest states in the U.S. Yep. Yep. The craziest states indeed. Connie, thanks for the 2. Yeah, he tried my ex for a CSA of neighbors' kids, not my kids. So they just skipped that out. That's nuts. What you're saying with that. And added to that, or 2 neighbor kids, 4 of our kids. See the failures in law. We need some true advocates that change up laws, because again, all these people run on protecting women and children. You know, not men. They don't ever talk about that, but they talk about protecting women and children. And are they really? Casey, thanks for the 10 there. I was abused when I was a kid and adult. I finally left and got mental help. I told my mom I got help and I'm on meds, and she said, why? You don't need that. You'll get over it. People say that stuff. It's in the past. Oh, it's this and that. No. You know, if you went to war, nobody would say that. But, you know, the things that children go through, they impact them the same way. PTSD tests. You know, you've heard in trials where people have faked PTSD. It's because, you know, they'll go through and they'll answer X amount of questions for X amount of symptoms, and they'll hit everything on there. And the reason that comes up as fake is because there are specific items go into childhood, certain types of abuse, and so on, but it's so ridiculous. That's horrible. That's horrible. I'm sorry you went through that. Ginger Jim, thanks for the two. Silverman said Mr. Feather's name with such disdain. Indeed. I noticed that. Fallen Hero, thank you for the gifted membership too. Thank you for being here too, my friend. Susan, thanks for the 10 there. Funny how Silverman can submit the complaint for Puerto Rico as relevant, but Ohio records not relevant. Make it make sense. Make a lot of this stuff make sense. I mean, honestly, Lord. Mimi, what's up? Thanks for the Rocket Pop Fund. Thank you. I appreciate that. Celeste, thanks for the cute chill time. Manicure money. The oldest has been talking about manicures, which is funny. She was like, Dad, go get a manicure with me. I'm like, I'm going to get a manicure. Shasta's Quarter, thanks for the live. Love hearing Precious voice. Love that not all men are abusers of the kids. You're awesome, Tug. Megan, too. Yeah, indeed. Here's the thing. I think a lot of times when we cover this stuff, when people do, they try to turn people against women. They try to turn people against men. And we're looking at individuals. Like laws are messed up on the books, but we were talking about.
Follow the facts.
Yeah, exactly. Wheezy Wheels. I like that name. Thanks for 5. 1:30 a.m. here in England. It's insomnia. Showing you guys. I just love listening to Bug jabber on. I know she's funny.
So
she just pops in. She's like, hey, by the way, I'm taking over. I'm like, okay. She told me, she said when she went away, she was like, I'll be back. And I was like, no. I was like, just leave the door closed for a little while. And she said, well, I'll be back. It's like, okay. Celeste, thank you. Welcome. Thank you for the membership. Welcome to Tug Stugs. Appreciate you. I've almost down to the bottom here. Angel, thanks for the 18 months. I officially hate this judge. How is he allowed to get away with this? Vile human.
I don't know. And we're asking the same question.
Oh, indeed. Terry, thanks for the 10 there. Can someone post the change.org to remove Thomas's? Need 232 signatures.
I gotta tell you, those change.org things, I know you guys love those, but they don't do anything. You can't remove a judge with a change.org petition. You have to petition the legislature of Florida to impeach him. That's the only remedy, or walk door to door for the next election when he's up for election and tell people in Florida why they can't vote for him. There is no change.org petition that will remove a judge. I hate to tell you that. None of those things do jack shit. And it's like the ruling class's way of making you believe you're doing something and you're not doing anything. Please don't waste your time on change.org. Please. It's one of my biggest pet peeves.
I saw this one for Teresa. She's like, I'm starting hashtag tugging for my 10 favorite people. Tugging, Megan. Tugging.
I love it.
Slippin' Jimmy. Slippin' Jimmy. Hey, I like that.
Absolutely. He is. I hate to say it because I love Slippin' Jimmy. But that type of lawyer, I do feel like this. We might be seeing that. I don't know.
Indeed. Marley, thanks for the $5 super sticker. Thank you. I appreciate that. Thanks for the 5. It's almost like this quote-unquote attorney and knows this case is a farce, including his little jabs periodically. Yikes! Giving Echard plenty to work with. I feel like that too. And last one here, Heather, thanks for 21 months. Where did this guy go to law school? I feel like man, what was that? Slippin' Jimmy went to what was it? Samoa, the University of
University of Samoa. This attorney actually went to ASU, but he majored in real estate, and he didn't get his law. He didn't go to law school at ASU. He went to law school someplace else. I don't know where. It's on his website. But I have a really bad feeling that I ran into him at a party at ASU. He looks familiar to me. Is all I'm gonna say.
I said, it feels like we're reading a middle school mock motion. This guy's an idiot, right?
I agree.
He makes it a genius. All right.
Go land crabs, Lamar.
land crabs.
Go
That's
land
funny.
crabs.
Yeah.
At University of Samoa. By the way, that's like one of the best shows ever is Better Call Saul. It's so good. But see, the thing that Slippin' Jimmy does is he uses his powers of manipulation for good. For most of it. Like there you won't find Saul doing a lot of super underhanded things to good people. He does underhanded things to get bad people. And that's different, you know? Doing these underhanded things though to like get this woman off of this, and he might succeed. That's the thing that bothers me here. Is that he might succeed. I have always been a little bit afraid of if she finds an attorney who will really fight, that she could walk from this. And
Yeah, they're convoluting the issue here. I mean,
Mhm.
it's, that's
Mhm.
all right. Where
if he
were we?
finds technicalities,
Mhm.
the law, will just overlook it. Period.
I'm disturbed by this case so much in so many
Oh,
ways.
I know.
All right, so let's see. Despite only being involved in this matter for a handful of days, the undersigned immediately discussed these allegations with Miss Owens to see what her response was. And that response was equally disturbing. It appears both statements by Mr. Echard's counselor are materially, knowingly, improvably false. Then why didn't anyone else?
Really?
Why
Really?
didn't they present all that stuff? Why didn't they present all this evidence to shoot it down?
Here we go.
Regarding the claim that Ms. Owens has no medical records that support her fake pregnancy, this statement is categorically, blatantly false. Immediately upon seeing this claim, Miss Owens provided undersigned counsel with a login and password for a Banner Health account. One of the medical providers, which Mr. Echard suggests, has verified it has no medical records relating to Miss Owens. Using that login information, undersigned counsel personally accessed Miss Owens' account, located a lab test result. So this is a lab test, June 1st.
It's a P test.
Yeah. Which says, again, it's the HGZ,
HCG.
I keep saying GZ
positive.
for some reason.
This Yeezy. This is a form of pregnancy test.
H-Yeezy.
It is a P test. What he is avoiding saying is that it is a urine test. If it were blood, he would be writing blood test all over this. But he knows damn well it's not a blood test. And this is the exact same record that we have seen over and over again. Dave Neal has shown this record. We have seen Reddit. It's been all over Reddit. This is a pee test. Chat, you had your chance to pee. Now you can't pee because we all peed before. And if you didn't pee then, you've missed out on the peeing. Okay? Just saying.
Roll down for the H. I mean, that's what it's saying right there.
So this is the positive P test that we've seen over and over again. And in fact, she took a P stick test in front of Clayton that came up positive. Okay, so what? We have all acknowledged and admitted she probably had a positive HCG test, but nobody believes it was because she was pregnant.
A man can have one, if you have like testicular cancer, it can actually show.
Apparently, if you have AIDS, it'll come up on it'll make a pregnancy test positive too.
So, I mean, there's all kinds of, reasoning again that says you have to follow this up. All right, so let's roll down. Let's see what's
now. A bunch of people in the chat are like, "I'm peeing right now." You don't need to share that with us. I think we're at line 15.
Yeah, absent some other explanation, this conclusively refutes Mr. Echard's claim that no medical records exist to prove Miss Owens was ever pregnant.
Well, here's the other explanation, sir. The other explanation is she wasn't pregnant, but she was either on some medication that made her HCG test positive, or it was fabricated in some way. But it still doesn't mean she was pregnant. And it's not a medical record that proves it. It's a medical record that gives a sign of it. There's another yikes coming.
Yeah, I saw that. I saw the big yikes there. Yeah. Regarding the second point, the suggestion or implication, every medical provider, again, not said, that's not what they said, mentioned by Miss Owens confirmed they have no records of treating her. That point has been shown to also be seriously misleading, if not entirely false. Specifically, and to use just one example, Mr. Eckard's counsel claims he sent a records request to Banner Health seeking treatment records related to Miss Owens. Mr. Eckard's counsel represented to the undersigned that in response to this request, Banner confirmed that that it had no such records. Again, yikes. But is it true? Oh my God. This is such a ridiculous thing. No, it is not true. As before, that serious allegation was immediately discussed with Miss Owens, who quickly provided an explanation. Yes, Banner did send a letter to respondent's counsel stating that it had no records responsive to his request, but not because no records existed. Rather, Banner's response was based on the fact Mr. Echard asked Banner for records from the wrong location. Below
Right,
is part.
This sounds like it's going to be a big reveal, and I was like, "Oh my God, is that true? Oh my God, are there records from this other Banner Health?" No, it's the same HCG test. It's the same damn thing. There's nothing else here.
Below is part of the response Mr. Echard received from Banner, indicating it did not have any records related to Miss Owens, quote, for the facility and or provider you requested. This identified Banner, Urgent Care, Scottsdale, and Shea as the facility for which records were sought.
Okay, so it says Scottsdale and Shea, no dates of treatment. Okay, fine.
Mr. Echard claims, aha, liar, gotcha.
He literally never said that.
Yeah, I remember him like standing up and being like, aha, gotcha. I mean, what's stupid?
What? Liar, gotcha. This is an emotion, a legal motion. Are you not embarrassed, sir, in front of a judge? I would love to be a fly on the wall of Judge Mata's office when she reads this.
There's a level beyond embarrassing. You know, this came to me from after I saw Amber Heard trial. It's called embarrassing. This is embarrassing.
This is it.
Yeah.
You know what? Judge Mata, by the way, is so polite and such a nice person that I don't think this will flip her trigger to go off on this guy. But I imagine that in private. Oh my God, Legal Vices is in the chat. Thank God. Legal Vices, I need a lawyer's opinion on this. And he just goes, a 12-year-old wrote this. I sent it to him earlier because I really wanted him to look at this and tell me, I can't be the only one that thinks this is insane. Can I? Am I the only?
Come on Thursday and talk about it.
Yeah.
Yeah. You know, come on Megan's channel.
Jeff, I don't know if Jeff is he around at night? What are you doing at 7 p.m. Eastern time, Jeff? It's isn't it 8 in the morning for him? I think he's on his way to work by then.
Perfect. Yeah. Just skip work and laugh about this stuff.
Skip work on Thursday, Jeff, and come talk about this with us. This is so insane. It's insane to me. All right, go ahead.
Okay. He claims this is proof Miss Owens lied about seeking pregnancy-related medical care from Banner. But if Mr. Echard's counsel had bothered to actually meet and confer in good faith before the instant motion was filed, as Rule 9 required, a far less nefarious explanation would have come to light. Banner had no records of Miss Owens being treated for those locations, it noted, because that is not the location where Miss Owens went for care. Rather, Miss Owens immediately provided a receipt showing she received care on June 1st, 2023 at the Urgent Care on Greenway and 64th Street.
All right, can I just say that I am horrified by how close this is to my parents' house? That's all I have to say, because Greenway and 64th, I can literally picture it in my mind. And I think I've actually been to this Urgent Care with my children. My parents live in Scottsdale, so it's just it concerns me that this woman is loose and in the neighborhood where my parents are. We've seen this, folks. We've seen this before. This is nothing new. In fact, we went over this on my channel. We actually looked at this and we went, this picture is actually bigger than this cropped picture. And in the original, you can actually see that she's sitting in a room where you would see the doctor, an examination room, and she's holding the bill. And we had this whole conversation about, hey, do they normally give you the bill before your scene? Because she's sitting in the exam room holding a bill. And then we heard from people who work at urgent cares that yes, sometimes they do that. Okay, fine. But this is not new. This is the same HCG test, P-test that she got at the urgent care, okay? This is not new. So again, this is the same thing as this. Oh wait, not this. The other thing. This thing here. See this? Banner Health positive results. This is her receipt for being there. This is the same damn HCG test we've been talking about from the beginning of this, June 1st. June 1st, people.
Everyone knew this existed. They've known this
June
existed from
1st.
jump.
We do not consider this to be a medical record proving pregnancy. No, this is just a sign of pregnancy that was not ever corroborated by blood test, by sonogram, or anything else.
That's wild, though. It's so wild that
I don't
they're
consider
like,
that a
aha,
medical
gotcha.
record. I don't
Gotcha.
consider that a medical record in any way. No, I'm sorry, but like I make this argument all day long that is not the medical records I was speaking of when I said there are no medical records, because that medical record does not convince me that she was pregnant in any way.
Well, apparently you have to jump through hoops, mental ones, and then you'll understand it just like she's saying. Is this the right place, or were we down lower?
No, we're good. I think. Didn't we?
Wait, what's above us? Show me what's above.
This thing.
Oh yeah, we're in the right place.
Yeah.
All right. All right. This
trust me, Tug.
Trust you. I don't trust me to get the right place. What are you talking about? This shows two simple things. First, it is categorically false for Mr. Echard to claim, as he repeatedly has, that Miss Owens has no medical records that support her fake pregnancy narrative. That statement is false. And it is a point this court should take extremely seriously. Man, they're going to tear this apart, particularly since Mr. Echard claims Miss Owens is the one lying. Second, Mr. Echard does accurately explain he sent record requests to some care providers like Banner, and he received some responses indicating no records exist for Miss Owens. In the example above, the explanation is incredibly non-controversial. Mr. Echard simply asked for records from the wrong location. But Mr. Echard's no record found theme is also misrelating for another reason, one which he conveniently fails to mention. During her recent deposition on March 1st, 2024, Miss Owens was asked numerous questions about the name of doctors' facilities where she sought care, some of which are the same places that later said they have no records relating to Miss Owens. In her deposition, they're going to go over all these excuses. Oh, Lord.
I think he's going to have to redefine clear and cogent for me.
In her deposition, indeed, Miss Owens gave a clear, cogent explanation for this discrepancy. She made appointments with several doctors, then canceled the appointments for utterly innocuous reasons.
Oh, innocuous reasons? Sure.
She had the beer bug. Of course, complying with disclosure obligations, she provided the names of doctors whom she sought care from, but no care records exist for the doctor simply because she never actually received care from that. That's not how it works. They would still have a schedule. I work in mental health, and the way it works is you schedule, and then we have different coding, like, DNS did not show, CBC canceled by client, and it would be coded in there as an attempt, but it would still show that she was at said facility. She did attempt one. So,
but I mean, look, if you sought care from a doctor, but you never went and saw the doctor, did you really seek care from that doctor? Can you really
No.
say that you
But you
did?
would still, I mean, does she have proof of cancellations?
Yeah, apparently, yes. There's some proof of cancellation. But see, we knew she made appointments. That's not
Yeah, it doesn't prove
news.
there's pregnancy there,
Yeah,
know?
she made appointments, and then Reddit proved that anybody could go and make an appointment with Dr.
Yeah, see, it's
McCool.
gonna say that's what I mean. When you look at the records, it shows you tried to do it and it shows it's canceled. So when you go there, like you're saying, there is no, it's a documented cancel by client, CBC'd, in some way. Every place has its
Wait,
own.
whoa. The chat is trying to tell me something. Hold on.
What's that?
How could it have been denied already? How do you know this? Where are you seeing this? If it has been denied, I am going to owe so
This
much
has been
to Judge
denied?
Mata. I don't know. That would be so weird. That would be so weird. It has been denied.
Holy crap. I mean, this is garbage.
He tweeted it out. He tweeted it out. He actually tweeted out, "Good afternoon. Judge Mata has denied petitioner's motion for extension of time to respond to respondent's motion to compel filed yesterday. She is currently requesting a proposed order from Mr. Woodnick on his motion to compel." Holy shit. Holy shit. Do you know what that means? She
What's
is
that?
currently requesting a proposed order from Greg Woodnick. That means she is signaling to Greg, "I am granting your motion to compel.
yeah.
Write the order."
Yeah.
Write the order.
I mean, they
Fuck off,
gamed,
Laura Owens.
Yeah, they gamed so much here, and they wouldn't provide even basic documentation proving again that there was a pregnancy, not that you peed in a cup, but that you had follow-ups, that you actually did something with this, because there's a lot more that goes on, especially at that at that many weeks. I mean, you're talking about not, hey, I peed and something happened, in a week or two. We're talking about a lot of time. Oh my God. So the
Okay.
judge was as impressed with this as we were.
Yeah. I am shocked by this. First of all, it didn't even hit the docket until late this afternoon. Now, that doesn't mean that the judge didn't read it till then, because he filed it yesterday, but there was some kind of glitch, he said, and so the clerk didn't get it on the docket until today. So it's possible that the judge had all of yesterday to read it. But Judge Mata, let me just say something about Judge Mata. We talk a lot on my channel about bad judges, and I've been accused, and somewhat rightly, by some, of saying, you spend a lot of time talking about bad judges and about family court issues that go wrong, and you spend no time talking about good judges. And that's true. That's true. I will tell you, that's really true. And the reason is because those cases don't make the news. When things go right in family court, I don't ever hear about them. I really don't. The cases that I follow, they hardly ever go right. And so I feel like that criticism is it's legitimate in some way, because I don't spend a whole lot of time looking for good cases, right, Tug? Because they're not.
You're also not saying that it's representative of it's just like doctors, okay? There are plenty of really good doctors out there, but do we talk about the good doctors? Every now and then if there's a puff piece, but really what you're talking about are the ones that do horrible things to people. I mean,
Right.
they're the ones that we get documentaries about. We get Dr. Death the show.
Right. They make the news. And so it's very important for me to point out when I come across a good judge, like Judge Carroll in Florida, Judge Hunter Carroll from the Kowalski case, who drove me crazy, who I called a P word.
Wet ass P word.
I did. I called him that because I have problems with him not holding the defense accountable for the sanctions I think they deserve. But at the same time, like, this is a guy who called a lot of balls and strikes on both sides. And at the end of the day, I have to say, I thought he was a really good judge, and I think justice was served. And so I do use him as an example of a judge that I find to be really fair. And in this case, Judge Mata has given me every indication that this woman has had enough of this, and she knows what's going on. She is a mother also, and she had to listen to Corey Keith. Poor man. That poor man. I feel so sorry for him. I want to like sit him down and like ask him, really, what was that like having to argue in front of Judge Mata? You know, as a parent, and you have to say to her, you're mansplaining a miscarriage to her that could never have happened. This miscarriage that could not have happened. And every woman listening who's ever been through a pregnancy knows this is utter bullshit, right? Judge Mata is like, she was very fair to both parties. She was very even keeled. She just has this really good energy about her. She's the opposite of DeThomasis, by the way. She's like, she gets right down to business. She's like, counselor, it's your motion, go. Like, she doesn't waste anybody's time. I was very impressed with Judge Mata, and I don't throw that out very, willy-nilly. I don't say that like, hey, I think this judge is cool, unless I really do. And Judge Mata, I feel like she's the right judge for this case. And what we risk by allowing Laura to continue this and keep like dragging it down the road, what you risk is the judges shifting, because they do that. Like where Judge Mata won't be on this case anymore. And it's almost like a strategy to like keep it going down the road long enough to roll the dice and get a new judge in the case, because they rotate. And so that's a real problem, because you don't want a new judge on a case that's gone on this long, because she literally knows what's been going on. And this kind of denial this quickly within a day, oh, Judge Mata ain't having it.
Well, yet it's just like when we're looking at this, I mean, this stuff is absolutely crazy. I mean, and the judges ruled on some of this stuff. I mean, really, when you look at other motions, again, they may try to reframe it and approach it from a different direction, but the judge has already been through all of this.
Mm-hmm.
That's
and also, again, like I said earlier, I said he better be careful. He's walking into a courtroom where and a lot of times I decry this and I say it's not really fair that these same lawyers and judges all work together. But in this case, the judges before you, like Judge Mata knows the lawyers in front of you, them, you see them every day. And like some guy comes in from another type of law, he's not in this court all the time, and he throws bombs like this against a guy who's been a 25-year good standing member of the bar, an ethics professor, Greg Woodnick, and he's throwing bombs against Greg that are disgusting. They make me feel sick. Accusing Greg Woodnick, who has already been accused falsely in this case by this plaintiff. I'm yelling, but he's been accused by Laura Owens of graping her, of kidnapping and graping her. That's the kind of client you took on, sir. A woman who would send a note to a judge ex parte against her attorney's knowledge, accusing opposing counsel of graping and kidnapping her. That's the woman you took on. That's the woman that you're throwing bombs for. Holy shit, dude. What are you doing? Like, I'm not even going to mention your name. It's not ever going to come out of my lips, because you don't deserve the kind of spotlight I can put on you. You don't deserve it, because you didn't do your basic due diligence and actually Google this case. And I feel sorry for you in that way, because you didn't. But it is what it is.
I think some people
eat your gruel, man. Eat your gruel, because it's coming at you.
Well, sometimes it's a paycheck, you know what I mean? Hey, there's money, good money, like you said. We don't really know that for sure, but
gotta be. There's no way anybody would take this on and by the way, this was a 39-page motion.
Yeah.
How many hours do you think he put into this? She paid for this.
Yeah, I mean, some of this stuff is so wild and crazy. I'm like, that didn't take a lot of time. The other stuff, thinking, how can I come up with an excuse? Maybe that did take a little bit of time.
Oh, she paid for this. He didn't do this for nothing. Like, he's not stupid. He may be amateurish with his motion writing and like writes like a 12-year-old, but he's not stupid. He's not going to do it for free, because, at the end of the day, he's grifting on this. He's going to make his bank. And if he didn't, well, then I have questions about his IQ, because you got to get paid to do this kind of work.
Oh yeah. This better come with a fat payday, just to be honest, because this kind of stuff. I mean, your name being attached to it is
He
not.
should be lucky I'm not saying his name. Like, be grateful I'm not using your name, sir, because this is the kind of shit that stinks and sticks to you for a long time. And I'm making that choice because I do feel like he has an alternative motive, which is to just get more name recognition, because he's a social media whore. He's like one of these guys who wants to be socially media famous and be known to be the lawyer to do this kind of stuff. And I'm not going to play into that game. I'm not going to play that with him.
See, I hate this kind of, because this is the, when you're like, oh, well, this something gives whatever. Lawyers are hard to give a bad name sometimes, but there are good lawyers out there.
There are
but
jokes
a lot
for a reason.
Yes, indeed. And this is exactly where that joke comes from, Hey, you want to call a place here so we can cover some more of this on Thursday?
Yeah, absolutely. Okay, so we're on page 13. Page 13. So this is a good place to stop, actually.
Yeah, because we're at a good place, and
it's been denied.
Yes, so it actually changes when we're looking at it. All of the insanity where we're questioning whether or not this could actually be taken seriously. No, we know it wasn't. So.
And also, I want to say that on Thursday, we'll talk more about Matt Mulvey, and we're going to get into the email that, doxes him, and I didn't do it. It wasn't me. It was this dude, Laura's lawyer, who decided to dox her victim, Matt Mulvey, from San Francisco, that I had been keeping under wraps because his lawyer asked me to, even though she was nasty about it. And we'll get into that on Thursday on my channel. Tug and I we're gonna be live at the same time. So 6 p.m. Central, 7 p.m. Eastern, and I'll
watch something crazy come up that day too. Every time you pull, you're like, I'm going to go over this. It's like half the time you get to, you're like, oh my God, what just happened today?
That was so crazy too. We're like, what are we going to do? What are we going to do? And then at the last second, it was like, I don't know what not to do. Like, what are the things we don't do?
Yeah. We were like, okay, we've got this hearing we're going to go over. And, we're just talking about like, what are the what subjects are we going to hit there? And yeah, this thing fell like a bomb, I mean, accusing him of ARPing her. That's madness.
And also all the Trump references, and we're not even done with that. I don't think. I think there's more. It's insane. It's insanity. And I don't think that, I mean, in this day and age, you never know. Like, this kind of crazy shit might work. I don't know.
It's possible, depending on where you play it at. It could. Yeah. I mean, you don't know. I mean, there are some that politics is such a poison pen these days. Some people are like, yeah, it is like Trump. Oh my God. And you never know the Me Too stuff that could actually hit. I mean, you just don't know.
You don't know. But thank God Judge Mata seems like a reasonable, she's not taking any prisoners kind of woman. She's just done with this. And I think she kind of indicated that in the last hearing we saw her. She made Laura Owens sign that HIPAA form. And by the way, the allegations being made in this motion about how it's not true, the medical providers, she did have some of them. No, as you hear, he's got nothing. She made the appointments, but she canceled them because she was sick. What? So we still have, so it's true. What Greg said is true. What he said is true.
She lied.
She lied. She said she was being seen by all of these providers, by this OBGYN. She had just seen her OBGYN on November 2nd. She said she had seen her OBGYN on October 27th. But no, it turns out she didn't see any of them. She made appointments that she didn't show up for. That is not the same as being seen. And so there is no medical proof of pregnancy. None. Zero. Zip. An HCGP test is not medical proof. Sorry, it just isn't.
what's wild, and I hope that this really gets followed up on, are all the other instances. This guy, again, when he rolled in with this, he threw another again, all of the unredacted stuff. I hope that gets brought up, because he threw in names that were not public, and that was something that anybody that knew about those names went out of their way to shield, because like you said, at the end of the day, even if I disagree with them not speaking up, they are potentially a victim of this person. They would be, in the reference that we're looking at, they would be a victim.
A victim. And so I'm not going to go forward with somebody's name who's a victim. Like, I didn't do that. I respected his attorney who said he doesn't want to be known. And so I disagreed with it totally. I said, you know, he has a responsibility to come forward. There are other men being harmed by her. And if he knows anything about this, he needs to speak up, especially because of his status in the community, and people will believe him, you know?
Yep.
But no, I didn't do it. I kept it to myself. I kept that to myself. And yet this guy goes out and drops his name. So this is how underhanded and slimy this guy is.
That's abuse, man. I mean, it's an abuser being allowed to continue the abuse that they first perpetrated on somebody. And that's,
and by the way, Greg Woodnick, when he released his emails or information and the deposition that had the victim's name in it, he redacted it. So when it came out to the public, that name was redacted. So I don't want to hear anybody say it's Greg's fault because it was his email, because this email could have been redacted by Laura's attorney, and it wasn't.
well,
And
we've
it
seen
was
these
an
tactics.
email between lawyers, lawyer to lawyer. And you don't expect that someone's going to release your entire email, especially if there's sensitive information in it. Yeah, it's crazy.
Well, we've seen these tactics before. In the Depp trial, they accidentally put out an unredacted copy of all the addresses, phone numbers, everything for every witness that was there. They added it on to one of their motions. There was a non-redacted copy, and oopsie, it ended up out there. So everybody that was going to, talk about this from Depp's side, all of their information got dumped into the public.
Mm-hmm.
Yeah, nastiness. That's nasty stuff.
It's really, and it's purposeful. I feel it's purposeful.
Oh yeah,
He
I think that is
darn well that he probably shouldn't put that out there, and he did. And he not only put his name out there, but his attorney's name, and that attorney, by the way, is aggressive. And we will read that email on Thursday night, I promise.
Yeah, if that attorney decides to sue them, let us know. I would really love to cover that.
Yeah, I don't know if she would go after Laura's attorney or who she would go after, but
maybe
it's
the
not me.
for because he posted it on, he took it outside of the courtroom, posted it to a website, and again he threw it out there and redacted. And yes, it was not you.
I just thought of something. Oh my God. He did. He posted it on his own website, and then he posted it on Twitter.
Mm-hmm.
And he did that before anybody actually got a hold of the court document.
Mm-hmm.
So nobody, my usual sources weren't able to go to the Maricopa County Court today. It is possible that the Maricopa County would have redacted that stuff. And we'll have to wait and see what the Maricopa County copy looks like tomorrow, because I'll have it by tomorrow. If the clerk redacted some of this stuff and he didn't, he's in trouble. Like, he's in trouble because the judge ordered that medical records be redacted. She ordered that neither party. Oh my God. I just realized she ordered that neither party would release medical records. Oh my God.
Yep. So that desperate move there, that might well blow up in his face big time.
Oh my God. I bet that they would have redacted all the medical records.
You know they did. You know that they redacted all of that information. So, I mean, the stuff everything he put out there, it violated orders. And And again, not just, I mean, just it's slimy to throw another potential victim's name into the.
Oh, it's awful. It's awful. And you can't blame Greg because he thinks he's speaking to an attorney and
No, that has nothing to do
he
with
has
Greg.
privilege. Like he's telling this other attorney and we'll go over the email on Thursday because it's really something. He's trying to tell this attorney, hey, watch out for what you're getting involved in because here's all the stuff I know. And like he didn't even need to tell him some of the stuff. I think he was doing it as a professional courtesy to be
Yeah,
like,
he was like, get out now.
yeah, like I don't think you want to get involved in this. Like, look at what I have and look at all these people she's done this to. And then he turns around and just like publishes this, not redacted. It's insane, Tug.
I've seen bad lawyers. I've seen nasty lawyers too. I've seen lawyers that do, terrible things purposefully. And one of the things that always sticks with that, you're not doing your client or yourself any favors.
No.
You violate what that judge says. It's like,
I wonder if he knew about the judge's order to not release medical records because, I mean, again, these are nothing we haven't seen already, which is why it kind of was like when she made the order, I was like, well, we've already seen all the records she owns.
Right.
I don't think she has anything else. But still, like it was an order that neither party was to put out any medical records of any kind.
Well, and her side's claim was, look at what he's going to do with this stuff. He's going to put all of this stuff out there and,
Right.
He's going to shame me with it. And then her side's the one that does it. I mean, come on. I mean, you have to kind of love it. You have to kind of love it.
Somebody sent me a DM that was so funny. It said, I was worried that Laura had hired herself a Saul, but it turns out he's just a clown.
Yeah, just because you pop up under the big top doesn't mean you get Slippin' Jimmy. That's right. Oh, Lord.
Yeah, I don't think this is going to work out for him the way he thought it was. I think it's funny, though, that on Twitter, he said, wait, he said, for those following this saga, I want to report all facts, whether good or bad. The court just denied the motion I filed yesterday. This is not good. But it is not case ending. Litigation is a marathon, not a sprint, and it's never over until it's over. This will continue. I wonder how long it will continue. Like, how much money does this dude, how much money is on retainer for you to continue this nonsense?
I mean, just how long before you're just like, okay, I'm calling it, because another thing that is really unfair when we talk about this, if Laura Owens admitted that she did this, everybody be like, oh, it's her mental health. And people forget who the real victim is in this. They'll lose track. So she could get away, and societally, she would have a redemption arc very easily. People forget very easily for a woman offender like this. Everybody looks at it and like, why the hell would somebody do this? Obviously, she's got to be mentally ill. Therefore, you just get washed away.
Well, and the thing is that that's the perfect out for her. We've been saying it all along. Laura, and listen, Laura's lawyer, if you're listening, because I'm sure you are, that's what you should be trying to talk your client into here. There's no win here. You don't have the facts on your side. You need to talk her into saying, I am sick, I need help, and I'm going to go get that. And please take mercy on me because I couldn't help myself, or whatever bullshit you can come up with. And believe me, people will forgive her. You can't even believe how fast people will be like, oh, poor thing.
Yep.
Like that is clearly the only end to this. Admit to what you did. Say you're going to go get help, and then, check yourself into a hospital for a couple of weeks and then keep a low profile. For fuck's sake, don't do this. Don't go into this. She didn't do it. Now, I didn't do nothing is not going to work here.
Well, we already know. I mean, that's the problem. I think I got 6 super chats. I'm going to hit them real fast. There we go. All right, Colton. Colton noted, by the way. Thanks for the 2. Lawyer just posted on Twitter, motion denied. Yay. Indeed.
Yay. Yikes, not yikes.
Yikes.
Yay.
That is yikes.
Yikes.
Rach, thanks for the 2 there. Candy fun to avoid the meat grinder. Oh, yeah. The meat grinder. Oh, that's funny. The other day, I don't know if you were on here or not. I can't remember. Or maybe I was by myself. My oldest daughter came down here and she was like,
No, I was on with that.
oh,
It was
yeah.
hilarious.
Yeah. I was like, wow, the meat grinder.
Send those super chats. Or
you're going in the meat grinder.
Going in the meat grinder.
I was like, all right. Well, I said, we don't even we go right past the wood chipper. We go to a meat
grinder.
Well, Rhea Raya, thanks for the 2 there. This lawyer is missing the dang. Maybe they should make some suggestions on that. I wonder if when he's posting, I wonder if he closes his comments. I'm just curious, I'm not, but I want to make this very clear too. Do not bother these people in any way, shape, or form. You can take screenshots and talk about it or whatever, but these people want attention. So you deny them.
Do not find him on Twitter and start trolling him. Don't do any of that. This guy seriously wants attention. Don't give it to him. Don't respond to his tweets. Give him nothing. Nothing.
If you talk about it at all, again, screenshot what he says, repost it that way. Don't link to it. Starve it and it's really funny. I love the responses to stuff like that. When you do it, you get the attention that they want, and it drives them crazy.
He really wants attention. He thinks he's going to be famous on this, but his name is never going to leave my mouth.
What?
I went through here so fast.
You ran down the stairs fast?
No, I sit down.
Oh, you sit down fast. Oh, you slid down the steps fast. Okay, I got you.
I like sliding down the stairs. I don't fall
I used to love doing that. I know what she's talking about.
Yeah, she butt slides. She's like,
butt slide. I know exactly what she's talking about.
I slide downstairs with.
What did you tell me before? You were like, I'm going now. What was that you said? Do you remember?
I'm going.
No, when I was like, okay, go on. You were like, I'm going. What did you say? Do you remember?
I'm going.
Jesus. Jesus.
What are you playing?
Where
are you playing over here?
What am I playing? I'm not playing anything. I hit my phone and it turned off the chat.
Okay.
Yeah. She's like, oh, video. Are you playing games on your phone? I'm like,
I like playing games.
I know you do. I know. All right. Hey.
I play a little game, just a little.
We'll go upstairs for a few minutes, and then once I finish, you can play one game.
I want to tell you something.
Okay, tell me something.
I play without sleep.
Huh?
For 10 hours.
You want to go without sleep for 10 hours? No, I don't think we're going to do that tonight.
Please.
How long is 10 hours?
Maybe 5 hours.
Maybe 5 hours. Hey, did you tell them that you went to the eye doctor, right?
Yeah, I went to the eye doctor and my eyes were fine, but not that.
Yeah, I know my eyes are not fine.
Yeah,
it's cool. Like I've never seen how they do kids, that are, you can't just easily name every letter up there at 4, So what they do is they have versions of E's, like the E is sticking up.
I can't buy without
but they call them picnic tables.
Hey,
He's
Dad,
like,
I want my pup game now.
Yeah, maybe later. You go upstairs and then we'll talk about it.
Okay, can I see on your web?
Well, I've got to read these. They might not be appropriate.
Does she ever go down the stairs belly first, like
no.
head first?
No,
I
she was
used to
really
do that all the time.
When she was little, she watched me fall and break my toe, and it was not fun. We have a cast iron rail, and my little toe caught on it, and it pulled it sideways. It was awful looking, and I think that stuck with her. She's like, "No, I don't want to see that."
I used to belly slide down the stairs. Belly slide. That was a fun thing in the feety jammies.
What are you doing?
She's funny.
I want to look what are you
All right. Well, I need to read these real fast. Go upstairs for just a minute. And you come right back down in a minute. Okay. Let me just finish these. Okay.
You watch a show movie off the video?
Maybe I'll watch a show. All right. Maybe. I got to get up at 4 o'clock, so I don't have a lot of time to watch a show. But
Don't make it super annoying.
Okay, well we'll watch something short. If you go upstairs, I need to get off here though.
Hey,
but
Dad.
What?
I was It's 2 hours.
We'll talk about hours of staying awake, but you gotta go upstairs.
Okay.
Okay.
I will wait for hours and
She's
sleep like
if you can see her, it's really funny
Hey,
because she's
Dad,
walking
my eyes
backwards
don't
toward the
get black.
steps.
My eyes don't
Yeah.
get black when I don't get sleep.
Oh, your eyes. Oh, okay. Your
Of course
eyes are
she's walking
okay. All right, we'll go upstairs.
My
Go.
eyes don't get black when I sleep.
Okay. I got
Love you, Bug.
you.
Good night, Bug.
She is such a funny one.
God, she's so cute. 4-year-olds, man.
Yeah, they're
4-year-olds.
cute. I love they have their own language. You have to like try to interpret. It's beautiful.
They're the greatest. I miss my little ones.
I'm gonna run through these real fast before she comes back.
Yeah. Go,
Tracy,
go.
thanks for the file. I work for a pharmacy. A request like this, go to our compliance department for records requests of any of our 7 locations, all connected. Yeah, that's the way, any place that I've worked with, that's the way it goes too. You have a department that pulls that up. So Heather, thanks for the 2. Roughly how old is this guy? Mentally he's 14. It's funny. Heather, thanks for the 2. Probably makes sound effects when he's telling the story. Probably he's like, yeah, and then we went marching in. Yeah, I could hear him. That's awesome. Ginger Jim, thanks for the 2. Attend supplies cause low levels of HGG. Yeah, there's a bunch of stuff that sets that off. I was reading about it after we had one of the first discussions here. And Heather, this last one. Thanks for the 2. Not my monkey, not my circus, but I know the clowns. All right. You got anything you want to add here?
No, just tune in Thursday night, same time on my channel.
Yeah,
Tug
we'll
and
be
I
on
will-
Megan's channel. So
we will
for sure.
pick up where we left off. I know you guys are going to have a tough time tomorrow without me covering it, but other people will be covering it. I'm on spring break with my kids. So
Listen, Alicia's coming back. You can hear her all the way up the steps now. Listen. Let's see. She's already talking. All right, from the top of the steps. Hey, Dad. Hey, Dad. Hey, Dad. What?
I broke my dad right on the sole.
You what?
I broke my dad right here on the sole toe.
You didn't break your nail. What are you talking about?
The sole, no.
It's sore? Oh, there you
No,
go.
no.
Huh?
I broke my dad on it.
You broke your nail? Did it come off, all of it?
No.
Okay.
Just a little.
Just a little? Okay. I can't see it, but.
Cut.
Okay.
It's a little cut, but
Oh, my Lord.
can't
All right.
see
Well, you
it.
want to say bye? Because I'm fixing to get off here so we can watch your show.
Bye.
Bye.
I
Tell
will see you.
bye, sweetie.
Bye. I will see you. All right. Well, I'm going to jump off here, okay? 'Cause
Okay.
I've totally lost control.
Just to put
I
this
know. I
way,
can
now
feel
we
it.
put
I can
Yeah.
feel it. It's
All
good.
right, well,
Good night, everybody.
Good night, folks.
Give it like this.